Recording in progress.
Okay, this is case number 23 CR 58, State of Ohio versus Bradley Allen Clark. Are you Bradley Allen Clark appearing there from the jail?
Yes, sir.
All right. This is a sentencing hearing. Mr. Clark has entered a plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. It's being conducted by Zoom. His attorney is Dennis Kirk. He's appearing from his office. Appearing from the prosecutor's office representing the state is Assistant Prosecuting Attorney King. Mr. Kirk, do you and your client both agree that this matter can be conducted by Zoom rather than an in-person appearance before the court?
Yes, Your Honor.
And you're all right with that, Mr. Clark?
Yes, sir.
All right. If for any reason you might need to talk with Mr. Kirk during this hearing, since you're not seated in the courtroom, just tell me and I can put the two of you into a breakout room and the deputy will step out while you're talking and no one else will be able to see you or hear you, okay?
Okay.
All right. All right. As indicated, the defendant has entered a plea of guilty to the charge in the indictment of fifth-degree felony. Court did order a pre-sentence report. I've received that, and each of the attorneys had an opportunity to review a summary.
It has, Your Honor.
Yes, Your Honor.
All right. All right. Anything from the state?
Only was contained in the plea agreement, Your Honor.
All right. Mr. Kirk, on behalf of the defendant.
Thank you, Your Honor. So we originally were in here on September 11th for sentencing, and at that time the court noted, I may mispronounce the acronym, but TCAP or
yes,
applied in this case. So there was discussion of concurrent sentencing, and then the court asked my client if he would be inclined to maybe enter treatment upon release from the institution. So a assessment was ordered by the probation department, and then we continued the sentencing until today. According to the probation department and my client, he does not is not interested in pursuing a drug court at this time, so would ask the court to go ahead and proceed with sentence.
All right, Mr. All right, is the judgment order of the court, defendant B, and is hereby sentenced to a term of 9 months of incarceration in the Correction Reception Center. Pursuant to KECAP, this sentence will be ordered to rerun consecutively. You are serving a sentence for, what, a fourth-degree felony, Mr. Clark?
That's agreed.
Okay. Not on this case, on your other case?
Yeah.
Okay. All right. And so it's ordered that be served concurrently with that sentence. And according to the sheriff, you have 2 days of jail time credit on your initial arrest on the 19th of July, and you were released on the 20th, and then on the 19th of July you were here, I'm sorry, on the 13th of September, when you're here in September. So 3 days of jail time credit. Upon completion of this prison term, Mr. Clark, it is possible the Adult Parole Authority may choose to put you under what's called post-release control for a period of up to 2 years. It's optional, but they'll make that decision. If they do, you'll be supervised by an officer on the terms they set. If they determine that you have not complied, then they can return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence a judge in the new case can impose upon you, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time would be left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. All right. It's also ordered that you pay the court costs when judgment, grant, and execution is ordered. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, the court could permit you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court each hour you worked, judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right, thank you. We need Brandy Moore, please. All right, are you Brandy Lee Moore appearing there from the jail?
Yes, sir.
All right, there are 2 cases before the court involving the same defendant. Case number 23 CR 70, 23 CR 138, both styled State of Ohio versus Brandy Lee Moore. Ms. Moore is appearing by Zoom from the jail. Her attorney is Danielle Witt, so she's appearing by Zoom, as well as the prosecuting attorney's office being represented by Mr. King. Ms. Witt, this matter is before the court for sentencing in these 2 cases. Ms. Witt, do you and your client both agree this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
Yes, we are.
And you're all right with that, Ms. Moore?
Yes.
All right, since you're not seated next to your attorney in the courtroom, if at any time you need to talk with her about anything, and I'll put you and her in the breakout room, but just the 2 of you on the screen. No one else will be able to see you or hear you, and the officer will step back, so it'll be confidential, okay?
Okay.
All right, in case number 20, the defendant entered a plea of guilty, property of 4th-degree felony, and in case number 23 CR 138 to a charge of failure to appear, also a 4th-degree felony. Now, Mr. King, has the victim of the case in 23 CR 70 been notified of the time, place, and purpose of this hearing, the right to be heard? All right. Now, have each of the court did refer the matter for a pre-sentence report, did receive that, and I've reviewed it. Have each of the attorneys had an opportunity to review a summary?
State
Yes.
has, Your Honor.
All right, Mr. King, anything?
State would just ask that the court follow the joint recommendation in each case, Your Honor. That's all. Thank you.
All right, Ms. Witt?
Yes, Your Honor. We also ask the court to follow the joint recommendation and place Brandy on community control and to follow the joint recommendation.
All right. Ms. Moore, is there anything that you would like to say?
I would just like to go with what the court recommends, and I will be truly grateful for the opportunity to be successful on community control or whatever you guys have planned for me to do.
All right. Drug court coordinator for an evaluation, and I did receive that back and indicated that at this time she did not appear that it would be necessary for her to be in the drug court docket since she had a year clean prior to the this sentencing here. Also, she lives in Williamsburg, which is more than 1 county away. The drug court criteria persons to be residents of Highland County or adjoining county, so she does not meet the criteria for that. The court will order that the defendant be placed on community control in both cases under the and were you currently in any kind of a care program, Ms. Moore?
I got to go to Claremont County, and they were going to be sentencing me to treatment over there once I leave here. So I don't know exactly what the treatment is going to be, because I was supposed to have house after I left here, but I miscarried my child while I was incarcerated, so that takes that off of the table. So I suspect that they may send me somewhere different.
All right. Well, the place you on community control in both cases under these conditions. First, you're to obey all laws of all jurisdictions. Conduct yourself. Be truthful in all statements you make to the probation department regarding sentencing. Regarding supervision. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior permission. You're not use or have under your control any firearm, ammunition, dangerous, ordnance, weapon of any other type. Has effects similar to controlled substance, drug abuse, or instrument, device, or thing that may be used to administer them or prepare them for administration, except those for which you have a lawful prescription, and you must have a copy of that provided to your supervising officer within 24 hours of receipt. You're to submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any kind of alcoholic beverage, nor be present in places where they're sold or being consumed. Anyone who is a co-defendant in this case, or any other person who has a criminal record, member of a gang, or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense unless you have written permission of your supervising officer. And that would also apply to any family members that might fall within that definition unless you were living with them immediately before the commission of these offenses. After the date of this order, you may not order, marry, or establish cohabitation in a common law marriage type of relationship with another without written permission. You may not contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervisor information records so your ability to pay restitution, fees, or costs can be reviewed. I don't believe there is any restitution, is there?
There's no restitution, Your
All
Honor.
right, in 70? Okay. If you are referred for an evaluation or assessment for any treatment, therapy, counseling, training, or other educational programming, you're to submit to that. And if there's any recommendation for treatment or programming, you're to enroll in and successfully complete that. And that's one of the things I'm sure they're going to order you to do with your provider, because I think you're going to need aftercare. You're to pay the court costs of this action, make payment arrangements to do that. And you are to comply with any recommended aftercare for substance use disorder treatment, which is
Yes,
given
sir.
as SUD in the entry.
Okay.
Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant or any other property placed that's under your control where you're found at any time by any officer of the probation department. Now, in the event that you fail to comply with these conditions, the probation department will file a written notice of that with the court. You'll be given a copy. There will be a hearing. And you'll be entitled to have an attorney at that hearing. If the outcome of the hearing is that you have failed to comply with the conditions, at that time the court can revoke your community control and sentence you to prison for a period of 6 to 18 months in each case, which could be a total of up to 36 months in prison. If that happens upon completion of your prison term, the Adult Parole Authority could, at their option, put you under post-release control for a period of up to 2 years. And if they do, you'll be supervised by a parole officer under those terms. And if during that period of time they find that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of 1/2 of the prison term that was imposed for all violations. But if you committed a felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
All right,
No,
are you
Your
being held on any other charges besides these, Ms. Moore?
There's one out of Claremont County that I spoke of earlier.
Okay.
Yes.
They're going to come back and get you then?
Yes.
Okay, all right. When you are released from custody, you are to report to the probation department within 1 business day after that.
Yes, sir.
All right, thank you.
Thank you.
State of Ohio versus David Lee Jones. Present for the state, Assistant Prosecuting Attorney King. Present on behalf of the defendant is Sarah Varga. And are you David Lee Jones?
Yes, sir.
Mr. Jones has entered a plea of guilty to breaking and entering, a 5th-degree felony. Mr. King, has the victim of the offense been notified of the time, place, and purpose of this hearing, the opportunity to be heard?
Yes, Your Honor. Both victims have been notified and have elected not to appear.
Okay. There's no restitution?
That's correct, Your Honor.
All right. Now, have each of the attorneys received a copy of the summary of the pre-sentence report which the court has ordered?
State has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor.
Ms. Barber, on behalf of the defendant?
Your Honor, in addition to what is in the plea agreement, I understand Ms. Sturgill has submitted her recommendation for drug court and advised the court that he is in the Rulon Center. That is where he is at. That is actually who brought him to court today. Just wanted to make sure that that was on the record. He is currently admitted to the Rulon Center.
All right. Mr. Jones, anything you'd like to say?
No, sir.
Well, you were supposed to be there on the 6th and you didn't make it. Did you make it yesterday?
Yes, sir.
Okay. I've noticed also you've had some problems in getting to probation department when you're supposed to. Kind of coming in whenever you can make it, I guess. What's the problem there?
Transportation. It's the main issue.
What's that problem? What is that problem?
I don't have my license or a ride.
Okay. All right. Well, I'm a little concerned about, you do meet the criteria, and it does appear that you would be eligible to be in the drug court, but that requires a commitment, Mr. Jones. And the commitment is to becoming and maintaining sobriety, as opposed to just simply doing enough to stay out of prison or jail. And it's harder than regular probation or community control, because there's a specific goal there, which is life-changing for you, hopefully, if you do the right thing. I'm kind of sensing here you don't have that commitment. Tell me what you want out of your life here.
I want to be clean. I want to be a productive member of society. I want to be a father to my kids.
One of the things that's interesting to me is you have a problem with transportation to get to treatment or to probation, but every time you were tested, well, not every time, but on September 20, October 19, and November 2, tested positive for drugs. Now, I'm not aware that DoorDash delivers drugs to people's houses, so it seems to me you probably have transportation to get the drugs, but you don't have transportation to get treatment. So I'm really questioning your commitment here. So what I'm going to do is I'm going to admit you into the drug court, and I'm going to put you in uncommunity control, but you're going to go to jail today, and you're going to stay there until you go to STAR, because I think the first thing you need in your recovery is an attitude adjustment, and STAR has programming for that. And then I think once you get done with STAR, then transitioning to going into residential treatment would be the next step, because you clearly need to change your way of thinking. And I think you're wanting to go to drug court to stay out of prison. I'm going to say this right now, and I hope I'm wrong. I hope what I'm about to say is 100% wrong. But I have less confidence in you completing the drug court than any person I've admitted to date. I hope I'm wrong. And I think going to STAR for 90 to 120 days, and, staying clean, and learning how to become more responsible, I think will be helpful. And then I think transitioning from there to substance use disorder treatment facility, residential facility, will be beneficial. And so there's a bed available for you on the 15th, which is a week from today, so you'll be held in custody until that day. Now, the conditions of your community control are that you're to obey all laws of all jurisdictions and conduct yourself in a law-abiding manner at all times. You're to report when and as directed, be truthful in all statements you make to the law enforcement, to the probation department. You are to keep them informed of your residence, place of employment at all times, may not change either without prior permission, may not leave the state of Ohio at any time without prior written permission, may not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who is an inmate or prisoner in any of those facilities. You may not, because of your conviction, purchase, possess, use, or have under your control any firearm, ammunition, dangerous ordnance, or weapon of any type. If you were to do so, that would be a violation of both federal and state laws, subject you to prosecution. You're not permitted to have any of those as a condition of community control in this case either. You're not permitted to purchase, possess, use, or have under your control any type of controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of a controlled substance or drug of abuse that has effects similar to controlled substances or drugs of abuse, or any instrument, device, or thing that may be used to administer them or prepare them for administration unless you have a lawful prescription, a copy of which must be provided your supervising officer within 24 hours of receipt. You're not permitted to obtain a medical marijuana card, nor even with the passage of the new constitutional amendment yesterday, you're not permitted to possess or use marijuana because it's like alcohol. It's legal to use, but it's also a real problem for people that have addictive behavior or abusive behavior of substances, so you're not permitted to have any of those. You're not permitted to, or you must submit to drug testing when and as directed. You may not purchase, possess, use, or have under control any kind of alcoholic beverage, nor may you be present in places where the sold or being consumed is otherwise lawful. You're not to associate with anyone who has a criminal record, as a member of a gang or other criminal group, or any person who has in the past or could in the future. Influence you to commit a criminal offense and violate these conditions unless that's approved in writing by your supervising officer. You may not, after the date of this order, marry or establish cohabitation or common law marriage type relationship with another without permission, written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You're to provide the probation department with financial information and records so your ability to pay any fees, fines, or costs can be reviewed. You're referred for an evaluation or assessment for further treatment, therapy, counseling, training, and programming beyond that ordered by the court. And specifically, that'll come when they have plans for you to transition from STAR to treatment. You'll submit to that. If there's programming or treatment recommended, you're to successfully complete that. You'll pay the court cost and make payment arrangements with the clerk to do that. You're to comply with all the conditions of the drug court docket, which you've already had explained to you and signed for those. And you're to comply with your treatment plan as recommended. And you're to stay in jail until November 15, when conveyed to STAR. Now, if you fail to comply with any of these conditions, let me back up. By being placed on community control rather than being sentenced to incarceration, you're deemed to have consented to a search without a warrant of your person, your residence, your vehicles, or any property that's owned by you or used by you, or any other property placed that's under your control where you're found by any officer of the probation department. Now, in the event that the probation department feels that you have failed to comply with these conditions, they will file a written notice of that with the court. There will be a hearing if you are found to have violated these conditions. Then you can be terminated from the drug court docket, and you can be sentenced to a period of incarceration between 6 and 12 months and fined $2,500. If that should be to a prison facility under DRC, then upon completion of that, you could be placed under post-release control for a period of up to 2 years by the adult parole authority. And if you fail to comply with any of those conditions, they can return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition, whenever sentence a judge in the new case can imposed upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right, now, the CBCF STAR is a lockdown facility, but you have to complete that. If you don't complete that, that'll be a violation. And it won't mean I'll just look for another alternative. I'll just order you to serve the rest of the time in custody because you need to complete that or you're not going to make it. And so you told me you want to be clean. You know, it doesn't matter what you tell me, it's what you do. That's what matters. And so I hope that you are, once you get there, that you'll change your attitude and you'll understand that, you know, you're going to have to make a commitment to this. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded to custody. All right, State of Ohio versus Lula Bruns, case number 22 CR 209. Present on behalf of the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Sarah Barger. Are you Lula Bruns?
Yes, sir.
All right, Ms. Bruns has entered a plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. The matter was referred to the probation department for a pre-sentence report. I have received that and have reviewed that as each of the attorneys received a summary.
State has, Your Honor.
Yes, Your Honor.
I've also received a letter from Ms. Sturgill, the drug court coordinator, indicating Ms. Bruns has indicated that she does want to be involved in the drug court. She does meet the criteria and has enrolled in outpatient counseling with Soda Payne Valley. All right, Mr. King, on behalf of the state.
I'm going to what's contained in the plea agreement, Your Honor.
Ms. Barger.
This is what is contained in the plea agreement, Your Honor.
All right, Ms. Bruns, anything you'd like to say?
I just want to say thank you for giving me the opportunity to be able to do drug court.
And when did you start your sessions in Soda Payne Valley?
I start the 16th.
I'm sorry?
She starts the 16th.
Okay, you start on the 16th. Okay. All right. Well, Ms. Bruns, you know, you've had quite a number of contacts with the legal system, and, you know, on paper, you know, it looks like, you know, you're just continuing your ways. Drug court is created for people that are high risk and have histories that have not been successful in treatment, and you're one of those people. It's created for people just like you. And so what will matter is your commitment to change. As I indicated just in the case before, this is harder than regular community control because there needs to be a commitment to being sober. We focus, when we put somebody in community control, the idea is we want to keep them out of prison. And we provide, you know, opportunities and services for them and supervision. But basically, the goal is simply to keep them out of prison. And if people do just enough to do that, then, you know, that's successful. With community control in drug court, that's not just the goal. The goal is actually to focus on that person becoming sober and staying sober, because if you are sober and you stay sober, you're not going to go to prison because you're not going to commit any more crimes. And so it accomplishes that goal, but more importantly, it results in life-changing decisions by the persons that's involved. And again, when people tell me they need help, I always say, you know, I can't help you. None of these people can help you. They can give you the opportunity to help yourself, because until you make that commitment, you're not going to be successful. At this point, you know, we're going to give you that chance. And so it's the order of the court that you be admitted into the drug court docket, and it's ordered that you be put under community control under the following conditions. You're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed. You must be truthful in all statements you make to the probation department regarding your conditions of supervision. You must keep them informed of your residence and place of employment at all times. You may not change either without prior permission. You may not enter or leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor can you communicate with, intend to communicate with anyone who's an inmate in any of those facilities without prior permission. You may not purchase, possess, use, or have under your control any ammunition, dangerous ordnance, weapons of any other type, and you've already been disqualified for that in the past, because if you do any of those things, that would subject you to being prosecuted under both federal and state law. And it's a condition you not have any of those while you're under community control in this case. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance or drug of abuse that has effects similar to those. You may not have any instrument, device, or thing that may be used to administer those or prepare them for administration, unless you have a lawful prescription for both the substance as well as the device. You're not permitted to obtain a medical marijuana card while under the drug court docket. You're to submit to drug testing when and as requested. You're not permitted to purchase, possess, use, or have under control any alcoholic beverage, nor may be present in places where they're sold or being consumed, even if otherwise lawful. You're not to associate with anyone who was a co-defendant or any person who has a criminal record, member of a gang, or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions unless approved in writing, and that includes any family members that you may have been living with, unless you were living with them immediately before the commission of the offense. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any contact law enforcement or arrest, citation, conviction, or other charge of violating law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees, fines, or costs will be reviewed. If you're referred for an assessment or evaluation by the treatment team for any further programming of any type, you'll submit to that. If there's a recommendation for that to occur, you're to enroll and then successfully complete that. You're to comply with all the conditions of the drug court docket, which you've gone over and have signed a copy of those. And those are incorporated as part of this order. And you're to complete with your, successfully comply with your treatment program plan. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property or place that's under your control where you're found at any time, any officer of the probation department. There'll be no fine or suspension of driving privileges. You're ordered to pay the court costs, and if you fail to do that, then the clerk can collect that through various means, including levying upon bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court can order you to do community service, give you credit for each hour you work, and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice that with the court. There will be a hearing. You'll be entitled to have an attorney to represent you. If the outcome of the hearing is that you failed to comply, then at that time you can be sentenced to a term of incarceration of between 6 and 12 months, fined $2,500. If that incarceration is in a penal institution, upon completion of that prison term, the Adult Parole Authority may put you under post-release control for a period of up to 2 years. If they do, you'll be supervised on the terms they set, and if during that period of time they find that you have not complied, they can return you to prison, make you serve an additional period of up to half of the prison term for one or more violations. But if you committed a felony, then in addition, whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively as sentence in the new case. All right, is there anything further, counsel?
No, Your Honor.
No, Your
All
Honor.
right. Then you report to the probation department. All right, thank you. All right, this is case number 23 CR 112, State of Ohio versus Michelle Sines. Present on behalf of the state's Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Dennis Kirk. Are you Michelle Lynn Sines?
I am, Your Honor.
All right, Ms. Sines has entered a plea of guilty to counts 1 and 5 in the indictment, both aggravated trafficking of methamphetamine, a third and fourth degree felony. Thank you. The court ordered pre-sentence report. I have received a copy of that and reviewed it. Have each of the attorneys received a summary?
The state has, Your Honor.
I have, Your Honor.
All right. Anything from the state regarding sentencing?
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. I would note that count 1, the third-degree felony trafficking charge, does carry a presumption for a term of incarceration. This defendant also has felony charges currently pending in Athens County for breaking and entering and theft. I'm not exactly sure what the status of those cases, where they are today, but those charges are pending, is my understanding. This defendant also has a prior felony conviction in 2012 for attempted illegal assembly. Finally, I would note that the co-defendant in this case, while his circumstances were not identical, he was convicted of 2 third-degree felonies. He was sentenced to a term of incarceration, and just as this defendant, the co-defendant, his last felony conviction was also in 2012. So based upon those circumstances, the state is requesting a term of incarceration. That's all, Your Honor. Thank you.
Mr. Kirk?
Thank you, Your Honor. Would ask the court to grant community control and treatment in this case. My client is currently at a treatment facility known as Angels Harbor. She's completed the initial and is now in the aftercare portions, I believe. I do have a letter from them signed by Milton Newsom. I'm not sure if the court's familiar with him. He's a retired judge and just retired from the Ohio Supreme Court as a...
Yeah, I know Milton very well.
And he contacted me. When he did, he was very clear. I'm not calling as a judge or I'm not calling as an attorney, but he wanted to vouch for Michelle. He said that she had entered the program in April, done very well, and he did write a letter to the court if the court would like to have a copy of that.
Okay. I have a letter from Angel Harbor Supervisor, Mr. Gaston, as well as a clinical report, I believe. But
Okay.
if you want to provide that, I'll take a look at it.
With Mr. Gaston is here if the court would need any additional information today to vouch for Michelle as well. When I spoke with Mr. Newsom, he advised that not only did she come in April and get involved in the program, she's to the point now she's mentoring others and is doing extremely well. In regards to the Athens County case, I did check, and then she did advise and provide paperwork to me as well. She appeared before that court yesterday, pled guilty to breaking and entering a felony of the 5th degree, as well as theft, felony of the 5th degree, and was sentenced to, she's telling me she was sentenced to community control for 3 years and to continue in her treatment, which is listed in the entry that she brought with her today. So it appears she's resolved the Athens County case. She does have that prior felony, but it was in 2012. She's been good to stay in touch with me, did own up to the charges here. So would ask the court, given the success she's had with trying to get clean and sober, which is really the root cause of her criminal behavior here, that she be given a chance with community control and to continue in treatment. Thank you.
All right, Ms. Sines, anything you'd like to say?
Yes, Your Honor. I would just like to note that, treatment was not something that I chose to get, out of trouble. It was something I chose to try to change my path ultimately, not just temporarily, but be committed to changing my lifestyle, my people, my places, my things, all that. So one phone call ensued me going 3 hours away from home, and I just want to be able to continue my purpose, I believe, and to maintaining sobriety and a healthy lifestyle, and helping others find their path as well, Your Honor.
Well, Ms. Tynes, these are trafficking charges, and that is obviously a concern of the state, and I agree with them. That's one of the problems we have, although in your case, I think it's clear that your substance use disorder is a significant reason why these offenses are being committed. And the report that I have from Angel Harbor says that you've been there since April of this year, which was prior to the indictment in this case. And the report from Ms. Sturgill indicates you've done quite well, and she would be an excellent candidate for drug court, but you're more than one county away. But you've been successful during the pendency of this case. So I'm going to give you this opportunity. Now, you need to understand it's going to be a one-time thing. You're going to, I'm ordering that you be placed on community control for a period of 3 years under the following conditions. You're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed. You must keep the probation department informed of your place of residence and employment at all times. You may not change either without prior permission. You must be truthful in all statements you make to the probation department regarding your community control. You may not leave the state of Ohio at any time without prior written permission, and you must have that passed with you when you do leave the state. You are not permitted to enter upon the grounds of any correctional facility, nor may you contact or attempt to contact anyone who's an inmate in those facilities without prior written permission. Now, due to your past conviction as well as these convictions, you're disqualified or prohibited from purchasing, possessing, owning, using, or having under your control any firearm, ammunition, or dangerous ordnance. To do so would subject you to being prosecuted for additional felonies. It's also a condition you not have any of those or any other weapons of any type while you're on community control in this case. You're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects similar to those, nor any instrument, device, or thing that may be used to administer those without without a prior lawful prescription, and you must provide a copy of that within 24 hours of receipt. You're to submit to drug testing when and as directed. And as I earlier mentioned, we also do not permit people to have medical marijuana cards or to use marijuana, even though it's going to be constitutional and legal in 30 days. It's also legal to drink. You're not permitted to drink either. You're not permitted to have any alcohol beverages under your control, nor are you to consume or purchase them. And you're not to be present in any places where they are being sold or consumed, even if it's otherwise lawful. You're not to associate with any co-defendant in this case, nor any other person that has a criminal record as a member of a gang, whether a criminal group or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless that's approved in writing by your supervising officer. It applies to any family members who may fall within that definition. Now, obviously, it doesn't include being in treatment and groups and so forth, but it means outside of that, or if you work with people. But you're not to socialize with them, live with them, go places with them, because each of you have your own issues and you need to take care of yourself. After the date of this order, you may not marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or other charge of violating law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fees, fines, or costs can be reviewed. If you're referred by the probation department for any further evaluation or assessment for further type of programming, treatment, counseling, etc., you will submit to that. If there's a recommendation for that, you're to enroll in and successfully complete that. You pay the court costs of this action and make payments arrangements to the clerk to do that. You're to comply with and successfully complete the aftercare that you currently are enrolled in through Angels Harbor and any after that. Now, by being placed on community control, rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, your vehicles, or any other property place where you're found that's under your control at any time, any officer of the probation department. It's ordered that you make restitution in the amount of $80 joint and several with co-defendant Jason McCoy, and $40 alone to the Huntington County Task Force, and you'll make those payments through the victim escrow restitution account of the victim witness office and pay any fees that are charged for that. You're to pay the court cost and make payment arrangements to do that. If you fail to make those payments, then the court clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion, or then court could order you to do community service that would have to be done in this county, and you'll be given credit for each hour you work in an hourly rate set by the court. Now, in the event that it's alleged that you have failed to comply with these conditions, then the probation department will file a written notice of that with the court. You'll get a copy. There will be a hearing. If the outcome of that hearing, and you'll be entitled to have an attorney at that hearing, if the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your community control and then sentence you to a period of prison between 9 and 54 months and fine you $12,500. If that occurs upon completion of that prison term, the Adult Parole Authority may, at their option, place you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised on the terms they set, and if during that period of time they find that you have failed to comply, they could return you to prison and make you serve an additional period of up to 9 months for a single violation, up to 1/2 of the prison term for all violations. However, if your violation is a new felony, then in addition, whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, it must be served consecutively to the sentence in the new case. All right. Now, again, I want to emphasize, with your record, this is your one and only chance with this court. So make sure you take advantage of it. You need to see the probation department before you leave. Is there anything further, counsel?
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
The probation department's located. Okay. Good luck to you, okay?
All right. All right, this is case number 23 CR 102, State of Ohio versus Joey Allen Eiss. Present for the state, Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Dennis Kirk. And are you Joey Allen Eiss?
Yes, sir.
All right, Mr. Eiss has entered a plea of guilty to one count of aggravated possession of methamphetamine, a third-degree felony. The matter was referred to the probation department for a pre-sentence report. I have received that and reviewed it. He was also referred to the drug court docket, and we did receive a report from Ms. Sturgill, filed with the court on the 6th, indicated that Mr. Eisen had submitted an application, wishes to be admitted into the drug court docket, and does meet the criteria for the program. Not sure we have his application in the file, Ms. Sturgill. Oh, she's not here.
She was in here a minute ago.
Yeah, she's with, I believe, Ms. Eisen. You did fill out an application, didn't you?
Yes.
All right. Remind me to ask her about that. Okay. All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor.
Did you get his I don't have his application.
Yes, sir. It was filed a long time ago because of this was previously.
Oh, it was?
About a month ago.
Oh, okay.
Yes.
It ought to be filed with a letter.
Well, the letter was an update because the case got
Okay.
stopped while we're waiting on.
Okay, here, I did find it, August the 2nd. Okay.
Sorry about that.
All right, thank you. August the 3rd, actually. All right. Mr. Kirk?
Thank you, Your Honor. Would ask the court to follow the plea agreement with Community Control and Drug Court. My client had some pending charges that have all been resolved, my understanding is, so that would kind of pave the way for him to now enter into drug court and do the community control. So would ask the court to grant community control with drug court.
All right, Mr. Eisen, anything that you would like to say?
Thanks for giving me the opportunity to prove that I'm not that kind of person anymore. I appreciate it.
All right, and you just started the you're in the residential program now at Counseling Center, right? And you're down at Franklin Furnace at the moment?
Yes, sir.
Okay. All right. I think it was arranged by Ms. Sturgill. Did she set that up? Yeah, okay. All right. Well, Mr. Eisen, as I've indicated earlier, in some of the earlier cases, the drug court docket has higher expectations and requires a much greater commitment than just trying to stay out of prison on regular community control. But the reason for that is because it requires a commitment by the offender to become and maintain sobriety. And that's what the focus of the program is. It's not simply to keep you out of prison. We focus on the sobriety and the recovery and rebuilding your life, because if you do all those things, we're not going to see you back here. You're not going to go to prison. And so, again, I emphasize, it's on you. The treatment team's not going to change you. They're going to provide you opportunity to help yourself. But no one can simply help you. They can simply give you the opportunity and the tools for you to help yourself. And so I think that this is a big step for you, and I think it's the right step. And so the court is approving your application and admitting you into the drug court docket. Now, it's the order of the court that you be put under community control for a period of 3 years under the following conditions. First, you're to obey all laws, all jurisdictions, conduct yourself in a law-abiding manner at all times. You're to report when and as directed. You are required to be truthful in all statements you make to the probation department. You must keep your supervising officer informed of your residence, place of employment at all times. You may not change either without prior permission. You may not enter upon you may not leave the state of Ohio at any time without prior written permission. You must have that written pass on your person at all times when you're out of state. You may not enter upon the grounds of any correctional facility of any jurisdiction, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You may not purchase, possess, own, use, or have under your control any kind of an firearm, ammunition, dangerous ordnance, or weapons of any type. To do so would be a violation of both federal and state law, and you're prohibited from having those while you're under community control in this case. You are not permitted to purchase, possess, use, or have under your control any kind of a controlled substance or kratom or any variant or analog of any controlled substance or drug of abuse that has effects that are similar to those, nor may have any instrument, device, or thing that may be used to administer those unless you have a lawful prescription both for the instrument or device as well as the substance. You must submit to drug testing when and as requested. You may not obtain a medical marijuana card while in the drug court docket. You're not permitted to purchase, possess, use, or have in your control any alcoholic beverage, nor may be present in places where they're sold, being consumed, even as otherwise lawful. You're not to associate with anyone as a co-defendant in this case, or any person who has a criminal record, a member of a gang, or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions unless approved in writing by your supervising officer, which includes any family members that may fall within that definition unless you're living with them immediately before commission of this offense. You may not, after the date of this order, marry or establish cohabitation or common law marriage type relationship with another person without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide financial information and records to the probation department so that your ability to pay any fees or costs will be reviewed. If you're referred by the treatment team for an evaluation, or assessment for further programming, treatment of any kind. You're to submit to that. If they recommend programming, you're to enroll in and complete that successfully. You're to pay the court costs to make payment arrangements to do that. You must comply with all the requirements of the drug court docket, program description, which you have signed and is in a file, and those are incorporated as part of these conditions. You're to comply with your treatment plan as recommended. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property placed that's under your control where you're found at any time by any officer of the probation department. There'll be no fine or driving suspension imposed. Now, if you fail to make your court cost payments, the court could order you to do community service and give you credit. It'd have to be in this county. You'd be given credit for each hour you worked in an hourly rate set by the court. Each hour you worked to reduce your judgment by that amount until paid in full. Now, if the probation department feels that you're not complying with these conditions, then they will file a written notice of that with the court. There will be a hearing. You'll be entitled to have an attorney. If the outcome of the hearing is that you have failed to comply, then at that time the court could revoke your community control and then sentence you to prison for a period of between 9 and 36 months, fine you $10,000. If that happens upon completion of the sentence, the Adult Parole Authority may, at their option, put you under post-release control supervision for a period of up to 2 years. And if they do, you'll be supervised under those conditions by a parole officer, and if they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of the prison term for all violations. If you commit a new felony, then in addition to whatever sentence the judge in the new case imposes upon you, the judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence of the new case. All right, that completes the case. You're no longer under your pretrial supervision. You'll need to see the probation department, Ms. Sturgill, over there before you leave. Is there anything further, counsel?
No, Your Honor. No, Your Honor.
All right, thank you. Okay, this is case number 22 CR 248, State of Ohio versus Jordy Van Gundy. Present for the state is Adam King. Present for the defendant is Dennis Kerr. Are you Jordy Scott Van Gundy?
Yes, Your Honor.
All right. Let's see. Defendant pled guilty to count 11, which is aggravated trafficking in methamphetamine in the vicinity of a juvenile, in the vicinity, I should say, of a school zone, a third-degree felony. The matter was referred to the probation department for a pre-sentence report, which I have received. Actually, yeah, I have received it, yeah. Thought that was a different case number. All right, have each of the attorneys received a summary?
State has, Your Honor.
I have, Your Honor.
All right. Mr. King?
Thank you, Your Honor. The state is requesting that the defendant be sentenced to a term of incarceration. Let's start by noting that this is obviously a third-degree felony trafficking that was committed in the vicinity of a school zone. This defendant does have a prior felony conviction from this court for receiving stolen property. He was initially placed on community control in that case and given an opportunity at treatment. After multiple probation violations, he eventually did have his community control revoked and was sentenced to a term of incarceration. So based on those factors, the state is requesting a term of incarceration in this case. And also the defendant has agreed to repay the buy money, in this case, to the task force That would be $120 joint and several with Darcy Vinegar. That's all, Your Honor. Thank you.
$120, you said?
Yes, sir.
All right. All right, Mr. Kirk.
Thank you, Your Honor. As noted, my client was a defendant in another case in 2016, and other than that, has no other felonies. He is currently in a treatment in Wheelersburg, Ohio, Serenity Now, or I believe it's known as Serenity Now. Reports are that he's doing well. Appears he's doing well there. He's reported to me that it's time to take this serious and get things under control, and so that's what he's attempting to do. I understand that it is a felony 3 trafficking in a school zone in this case, but with it being his second felony, and with the history of, as noted in the PSI, of drug history, that meth, heroin, fentanyl, I think those are big issues for him, and I think he's finally tackling them. So would ask the court to give him one chance at community control with treatment. Thank you.
All right, Mr. Van Gundy, anything you'd like to say?
Yes, Your Honor. Since I've been in treatment, I've gotten back in contact with my son. Before that, I haven't talked to him in 3 years. I mean, treatment's really giving me my life back. And I would love to stay there if I could.
Mr. Van Gundy, I have a letter here from Melissa Fisher at Serenity Now, dated November the 2nd. And it says that Jordy Van Gundy left Serenity Now counseling on Sunday, October 29th, 2023 against staff advice. Client reported he was going to prison. He wanted to spend time with his family. Staff tried to encourage Jordy to stay in services with no success. Sounds to me like you just lied to your attorney in the court, because they say you're not there. You got anybody here with you from Serenity?
No,
They didn't bring you up here, did they?
No, Your Honor.
That's because you're not there, are you?
No, Your Honor.
And you just lied to me, didn't you?
Yes, Your Honor.
And why in the world would you do that?
Do
I look that stupid? Do I look like I have stupid tattooed on my forehead? Because if so, you need to get a pair of glasses.
I planned on going back to Serenity Now.
You plan on going back to treatment. Okay. All right. Well, Mr. Van Gundy, I really had thought that you would get community control in this case, since you were supposedly in treatment, but then we get this letter. And so it's the order of the court that you be, and you are hereby sentenced to the Correction Reception Center at Orion, Ohio, for a period of 24 months. Upon completion of that prison term, the Adult Parole Authority may choose to put you under post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a probation officer, or be a parole officer on the terms they set. And if during that period they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of the prison term for all violations. However, if you commit a new felony while under post-release control, then in addition to whatever sentence a judge in a new case can impose upon you, the judge is also authorized to sentence you, in this case, to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence of the new case. You're also ordered to pay the court costs, which judges grant and execution is ordered. If you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, assets, or other earnings you may have. If that doesn't collect it, then upon completion of your prison term, but not while you are in prison, you can do community service in this county and be given credit for each hour worked in an hourly rate set by the court. And each hour you work will reduce your judgment by that amount until paid in full. See, is there a mandatory fine in this case? I can't recall.
Yes, there is, Your Honor, $5,000.
Has there been any change in your financial circumstances since the last time I appointed counsel for you?
No, Your Honor.
All right, then the court will find that you're not able to pay that fine, and it will be waived. Now, according to the Sheriff's Department, you have 7 days of jail time credit, so that'll be credited against the sentence. Also made some notes here that you lied to the court about being in treatment, and so there won't be any judicial release. You can file for it, and I'll design it as soon as I get the file out and see my notes. All right, anything further from council?
Just restitution.
Oh, restitution is ordered in the amount of $120, Holliday County Task Force, joint several with the co-defendant, Darcy Vinegar, and that must be paid through the victim witness restitution escrow account, and you'll pay any service fees that are charged for that. All right, thank you.
Your Honor, I would also just like to put on the record that obviously even when I spoke today, that was information he gave me.
I indicated he lied to you.
Yeah, I just want to make sure the court knew that because I had no idea.
I knew you did. Yeah.
Thank you, Your Honor.
Yeah. Your Honor. All right, this is case number 23 CR 135, State of Ohio versus Kelsey Bruns. Present for the state is Assistant Prosecutor King. Present for the defendant is Attorney Jacob Wagner. And are you Kelsey Bruns?
Yes, sir.
All right. Defendant is charged with illegal conveyance and aggravated possession of a fentanyl-related compound. There was a motion filed for intervention, and I see that that is for a amended charge of attempted illegal conveyance, since the third-degree felony is not eligible for intervention. And this indicates that you're going to change your plea to an attempt to commit the offense of count 1, which would be a third-degree felony, but because it's an attempt, that reduces it by 1 degree to a fourth-degree felony, and it makes you eligible for this program. Now, this document contains a total of 4 pages, and on page, it's a plea of guilty and entry to admit you into the intervention program, and also an entry. Now, on page 3, toward the top of the page, there's a sentence that reads, "I enter this plea voluntarily," and below that appears to be signature Kelsey Bruns. And is that your signature I'm looking at here?
Yes, sir.
When did you sign this document?
Just now.
Just now?
Yeah.
All right. Now, is this something that you and your attorney have been talking about before today?
Yes.
And when you signed this agreement, is this something that it contained what you thought it would?
Yes, sir.
You're not surprised by it or anything? All right. You had enough time to fully consider the matter for making the decision?
Yes, sir.
And did you sign this agreement voluntarily?
Yes, sir.
Right now, under the law, normally when a person enters a plea of guilty, they are found guilty, and then there is a sentence imposed. That can be community control or probation. It could be jail or prison time. It could be a fine or a combination of those items. And that means that person is convicted and has a felony record. Now, if you plead guilty to this charge and are placed into the intervention program, that is a different mechanism. What the intervention program says is that, the law says, is if a person has committed an offense because of their substance use or mental health issues, then they can be put into a certified treatment program. And if you enter a plea of guilty, you're not found guilty. Instead, you're put into this program. And this program includes treatment, a treatment plan, as well as certain conditions of supervision through the probation department, which are not as strict nor as many if you were on regular probation. And even though you plead guilty, and that plea of guilty goes into the file, the court stays the proceeding. A stay basically means we just stop it until I hear a report from probation about your progress in the program. And I put you on this program for 2 years. And that includes that you cannot use any kinds of any types of controlled substances or drugs of abuse, nor may you drink marijuana, etc., for a period of at least a year. And you have to comply with the treatment program otherwise, as well as those conditions. And if you successfully complete the program, then, even though you pled guilty, once I'm told that you completed it by the probation department, the charge is dismissed. And so even though you pled guilty, you were never found guilty. And even though there's a plea of guilty in the file, somebody looks at it, you can still tell them, yeah, I pled guilty, but I haven't been sentenced, so I'm not convicted, and I'm in this program. And then once you complete the program, the court then will go ahead and set the matter to seal the record, and that will take it out of the records, and because it was dismissed, you've never been convicted, and so you don't have a felony record. So that's the big advantage to you in this case. Now, the disadvantage is this, and the reason we're going through this process here today. If you fail to comply with your treatment program, if you use drugs or alcohol without prescription or unlawfully, or if you don't comply with the conditions, if you take off and don't report, don't do the things you're required to do, then they will file a written notice of that with the court, and there will be a hearing. You'll be given a copy of that allegation. You will have an attorney at that hearing, and if the outcome is that you have failed to comply, then at that time the court could sentence you. Now, it wouldn't have to be prison. It could be prison, but it wouldn't have to be. It could be community control, which, as I indicated earlier, is more intensive, and there are more conditions and restrictions of supervision, and that can be for a period of up to 5 years. And you'd be supervised by the probation department. Now, the same thing works in that case as in this case, or in the case of intervention, if you don't comply. If they feel you don't comply, they file a written notice of that with the court, give you a copy, you have a hearing, you're entitled to have an attorney, and if the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your community control and then sentence you to prison for a period of 18 months and fine you $5,000. And if that happens, upon completion of that term, the Adult Parole Authority may choose to put you under post-release control, supervision for a period of up to 2 years under the terms they set, and if during that period of time they find that you have failed to comply, they could return you to prison to make you serve an additional period of up to 9 months for a single violation, but there is a limit or cap of half of your prison term for all violations. But if you commit a new felony, then in addition, whatever sentence a judge in the new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively, a sentence in the new case. Do you understand all that?
Yes, sir.
Now, are you a U.S. citizen, Ms. Bruns?
Yes, sir.
All right. Now, the charge in this case reads that, as amended, would read, well, let me read the original. The count one in the indictment reads as follows. On or about December 8, 2022 in Highland County, Ohio, you did knowingly convey or attempt to convey onto the grounds of a detention facility, the Highland County Sheriff's Office, a drug of abuse, as defined in ORC 3719-011, to wit, a fentanyl-related compound. The violation of Section 2921.36A2. So as charged, that's a third-degree felony with a 9 to 36-month prison term. Now, by reducing it to an attempt to commit that offense, that reduces it to fourth-degree felony, carries a possible prison term between 6 and 18 months, and a fine $5,000. And also carries a possible license suspension of 6 months to 5 years. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged that you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses that might be raised in trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, other than being promised to be put into the intervention program if pleading guilty to the amended charge, has anyone promised you anything other than that to get you to plead guilty?
Sorry, can you repeat that?
Other than entering a plea of guilty, in page 2 it says you're going to enter a plea of guilty to count 1 as amended, and your state's going to dismiss count 2 and recommend intervention, and you agree to cooperate fully with the state. Other than that, has anyone promised you anything?
So boiling it down, beyond the fact that if you complete the program, you're getting into the intervention program, I've not made you any promises, judge hasn't, prosecutor hasn't.
No, sir.
Okay. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No.
Right, now you have certain constitutional rights you must understand before it can accept a plea from you. First of all, you have a right to have an attorney in this case, and Mr. Wagner was appointed to represent you. That wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you wish him to provide. So if you decide you do not want to do this, that you want to defend against the charge, he'll continue to represent you, including in trial, if that's what you want. Do you understand that?
Yes, sir.
Yep. I still don't have that. I want you to call the bridge and tell them.
Who's this for?
The 10 o'clock in Gilroy.
Okay.
And then I want you to also give me the number for the Department of Corrections Director. I'm going to write them an email. I'm tired of this crap. This is ridiculous.
Okay.
And also, you can give me some more coffee. That might make me a little less hungry. All right. Now, you have a right to have a jury trial on this charge, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They would be instructed on the law. And then that jury would have to decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive or give up in writing, thank you, your right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge will hear the evidence, the judge will apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney in open court. What that means, the witnesses against you have to come into court to testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront the witness, to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order. It's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
I did hear you.
Yes, sir.
All right, thank you. Now, under the Constitution, you have privilege against self-incrimination. What that means is that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one can even comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio of every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't even have to put on any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights that I've just described for you. If you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, and that you committed that crime. And that plea waives or gives up all of the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and to cross-examine through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you say you're guilty, that's what's used to find you guilty. Waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I sentence you the maximum sentence, or under other certain circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge as amended or the possible penalties for that offense?
Yes, sir.
Do you understand?
Yes, sir.
Have any questions about the intervention plan, or what would be required of you, what you have to do to successfully complete it?
No, sir.
You understand?
Yes, sir.
Have any questions about the plea agreement? You understand it?
Yes.
Do you have any questions about the constitutional rights I've explained?
No, sir.
Do you understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
Is there anything you need to speak with your attorney about before we go any further?
No.
Then is it your decision to withdraw your not guilty plea, plead guilty to the amended charge of attempt to commit the offense of illegal conveyance of drugs as alleged in the indictment pursuant to the terms of the plea agreement?
Yes, sir.
All right, then as to the amended charge, which would read that, at count 1, that on or about December 8, 2022 in Highland County, Ohio, you did knowingly engage in conduct which, if successful, would have resulted or constituted the offense charged in count 1 of knowingly conveying or attempting to convey onto the grounds of a detention facility, the Highland County Sheriff's Office, a drug of abuse as defined in ORC section 3719.011, to wit, a fentanyl-related compound, in violation of section 2921.36A2, a felony of the 4th degree as amended, carrying a possible prison term of between 6 and 18 months, and a fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. You can be seated. All right, the court finds that on this day in open court, the defendant was advised of all her constitutional rights, made a knowing, intelligent, voluntary waiver of those pursuant to Criminal 11. The plea is accepted and ordered filed. The defendant has filed a request to be put into the intervention program. She is currently in treatment at the counseling center, and that's residential treatment, right? Yes. Okay. And so that is a qualified program. And therefore, the court finds that she is not a repeat or dangerous offender. She is otherwise eligible for community control supervision sanctions. That she is otherwise eligible for intervention in lieu of conviction under the statute. And the court further finds that her drug usage, alcoholic usage, mental illness, was a contributing, or were contributing factors leading to the criminal offense with which he has been charged and entered a plea, and that intervention in this case would not demean the seriousness of the offense and would substantially reduce the likelihood she would commit any future criminal activity. Therefore, it is ordered that the defendant's plea of guilty be accepted. However, there will be no finding at this time of guilt. Rather, the case will be stayed pending a report from the probation department concerning the defendant's progress in the program. The defendant is placed on community control for a period of 2 years under the conditions that the court has approved for this program, and you'll have to comply with those. And probation department will go over those with you. You will be required to successfully complete your intervention plan, which is your treatment plan, and it's also required under law that you do not use any drugs or alcohol for a period of 1 year. The only exception would be if you have a lawful prescription, in which case you would have to present a copy of that to your probation department immediately upon receiving the drugs. Now, in the event that you're also to pay the court cost of the proceeding. Now, in the event that you successfully complete your intervention plan and you obey all other conditions of the community control, then the court will dismiss the charge against you and will set the matter for a hearing to seal the record. And 99% of the time those are granted because there's no other reason for the case to be open, and that would seal the case. In the event that you fail to complete or allegedly fail to complete or comply with the plan or comply with the conditions, then the probation department will provide a written notice of that to the court, give you a copy. The court will hold a hearing. You will be represented by an attorney at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your participation in the program, find you guilty, and then proceed with sentencing. At that time, the sentence could include a prison term of between 6 and 18 months and a fine of $5,000 and a license suspension. And as I said, you're to pay the court cost. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
Okay, so this completes the case then. You're no longer under house arrest or any of the other pretrial supervisions. You'll need to report to the probation department. You want her to see you on the way out. See Ms. Sturgill over there, and they'll set you up for an intake to put you under the new supervision plan. All right, thank you.
Yes, sir.
Stick around till I talk to you, okay?
All right. From the bridge.
On the record, Your Honor.
State versus Dunstable Local, L-O-E-C-H-E-L, 22-0-013. This is a hearing was set for sealing of a record. The defendant successfully completed the diversion program. The court has dismissed the charge, and the prosecutor has not filed any objections, and therefore the court will order the record sealed. Are you Ms. Nisley? Okay, all right, thank you. All right, case number 23 CR 180 State of Ohio versus Jonathan A. Meadows. Appearing on behalf of the state, Assistant Prosecutor Adam King. Appearing on behalf of the defendant is Attorney Sarah Barger. And you are Jonathan A. Meadows?
Yes, sir.
The defendant entered a plea of guilty to one count of aggravated trafficking of methamphetamine, a fourth-degree felony. The court ordered a pre-sentence report, and I have received that report and reviewed that, and of each of the parties had an opportunity to review a summary.
State has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only what is contained in the plea agreement, Your Honor, and there is restitution to the task force in this case in the amount of $25. That's all. Thank you.
Ms. Barger?
So what is contained in the plea agreement, Your Honor, my client is aware of the restitution.
Mr. Meadows, anything you would like to say?
I'd just like to say this program's helping me out a lot. It's helping me to maintain the goals that I need to stay clean and to stay away from the person, places, and things that I don't need. Thank you.
You're still in the residential program, right?
Yes.
Okay. It went in on the 6th of October, it looks like?
Yep.
All right. All right. Well, it's a judgment of the court then that the defendant be and is hereby sentenced to a term of 3 years of community control supervision under the supervision of the Highland County Probation Department. And you're ordered to comply with the following conditions, Mr. Meadows. First, you obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed, be truthful in all statements you make to the probation department regarding your supervision. You must keep them informed of your residence, place, and employment at all times, may not change either without prior written permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with any person who's an inmate in any of those facilities without prior written permission. Now, because of your conviction, you're prohibited under both federal and state law from possessing, purchasing, owning, using, or having under your control a firearm, ammunition, or dangerous ordnance. To do so would be a violation of both federal and state law to subject you to being prosecuted for a felony. It's also a condition that you not have any of those during your supervision in this case, nor may you have any other weapons of any other type. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has an effect similar to those, nor any instrument, device, or thing that may be used to administer or prepare any of those for administration unless you have a lawful prescription, both for the substance as well as the device or equipment. You must submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any alcoholic beverages, nor may you be present in places where they're sold or being consumed, even if otherwise lawful. You're not to associate with anyone who's a co-defendant in this case, or any person who has a criminal record, is a member of a gang or any other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions, unless that's approved in writing by your supervising officer that apply to any family members immediately, unless you were living with them immediately prior to the commission of this offense, if they fall within that definition, I should add. Now, after this date of disorder, you're not permitted to marry or establish cohabitation in a common law marriage type of a relationship with another person without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so that your ability to pay restitution, fines, fees, or costs can be reviewed. If you are referred by the probation department for an evaluation or assessment for any treatment, therapy, counseling, training, or other programming beyond that ordered by the court, you're to submit to that, and if there is a recommendation that you undergo programming, you're to enroll in and successfully complete that. You're to pay the court costs of this action and make payment arrangements to do that. You'll be required to successfully complete your substance use disorder treatment. Substance use disorder is abbreviated as SUD in your entry, as well as completing any aftercare at TCC or thereafter that TCC recommends. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property place that's under your control where you're found at any time by any officer of the probation department. There will be no fine or driving suspension imposed. You're ordered to pay restitution in the amount of $25 to the Highland County Task Force through the Victim Restitution Escrow Account, pay the service fees charged for that service. If you fail to pay any of those costs, then the court clerk will collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that does not collect it, then upon the court could order you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court, and each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice out of the court. You will be given a copy of that. There will be a hearing. If the outcome of the hearing is that you have failed to comply, then at that time the court could revoke your community control and sentence you to prison for between 6 and 18 months, fine you $5,000. If that occurs, upon completion of that prison term, the adult parole authority may put you under post-release control for a period of up to 2 years at their option. If they do, you'll be supervised by the parole officer, and if they determine that you have not complied, they can return you to prison to make you serve an additional period of up to 9 months for, well, in this case, half of your prison term for one or more violations. However, if you commit a new felony, then in addition, whatever sentence could be imposed by the judge in the new case, that judge could also sentence you for committing that offense under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in that new case. All right, is there anything further from counsel?
There you are.
Yes, Your Honor. I'm sorry, there's one thing that I need to address. My client's phone was seized during his arrest and has not been released, and we're wondering if he can get that back from the Greenfield Police Department, if the court can order a release for that.
There's no reason it shouldn't be returned.
Not that I'm aware of, Your Honor.
All right. Well, I hesitate to order things to be released that I didn't order seized, but I'll put it in here for that. So, defendant's phone be returned. All right, Mr. Meadows, then you're no longer under pretrial supervision conditions. This completes the case. See Ms. Sturgill over here, and she'll tell you when you need to get in contact with probation for them to give you the intake papers and go over the new conditions with you. All right, thank you. I'm adding that to the
Your Honor, may I approach?
Sure. Don't have that. No, thank you. Are these copies?
This was the deputy gave to me.
All right, case number 23 CR 140, State of Ohio versus Mandy Jo Nisley. Present for the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Catherine Hapner of Hillsborough, Ohio. And are you Mandy Jo Nisley?
Yes, sir.
Ms. Nisley has entered a plea of guilty to counts 1 and 2, breaking and entering, in violation of section 2911.13a, fifth-degree felonies, and matters before the court for sentencing. Mr. King, have the victims of these offenses been notified of the time, place, and purpose of this hearing, and the right to be heard?
Yes, sir, Your Honor, and he is elected not to appear today.
All right. Is there, has each of the attorneys had an opportunity to receive a summary and review that of the PSI?
State has, Your Honor.
I have, Your Honor.
All right. The case was referred to the drug court docket for evaluation, and Ms. Nisley has filed a written application and acknowledgement of the receipt of the program description. And the clinical director of the drug court has indicated that she meets the clinical criteria for admission into the docket. All right. Anything from the state?
Only was contained in the plea agreement, Your Honor. And there is restitution in this case to Justin Cutler in the amount of $1,107.
1,000?
$1,107.
Okay. I wrote it down as 1,070. Okay. 1,107.
Yes.
Okay. I better redo that. All right. Thank you. All right. Ms. Hammer?
Thank you, Your Honor. We would ask that you admit Mandy into the drug court. She has been doing very well. I think the court is probably familiar with her, knows that she does have, unfortunately, a long history of drug use and abuse. However, she is addressing that. She's been at the Georgie Harris house. We've given you her certificate of completion there. And I think that she is truly motivated at this point to get clean, stay clean, and take drug court seriously. So we hope that this will be the end of her appearances in this court, well, other than drug court appearances, but as far as new cases go, and she can get her life on track and stay on track.
All right, Ms. Nisley, anything you would like to say?
Your Honor, I would just like to say that I wish I could have done this a long time ago, as opposed to opting out to just go do time, which was easy, because this has been the hardest thing I've ever did in my life. Doing prison time was wreck. This whole actually taking this serious these last few months and buckling down has been the hardest months of my life out of all my years. And I wish I could have had this opportunity a long time ago, but I'm glad that I have it now. And I'm glad that I was given the opportunity to get sober and to have the accountability in order to stay sober. Thank you.
All right, thank you. Well, as you acknowledge and your counsel acknowledges, you've had a long history with the court, not the worst I've ever seen, but certainly not the best. And, you know, and I don't think you were here earlier, I've had a couple other people here this morning that I've sentenced to drug court, is that drug court is much more difficult than community control, more difficult than serving time. You know, you can serve time because you've done it. The question is whether or not you'll be committed enough to be able to complete this program and change your life. And I think that you may have reached that point. It takes people different times to get to that point. But at this point, the court is going to accept you into the program and give you that opportunity. And so you're admitted into the drug court docket, and it's the order of the court that you be sentenced to a period of 3 years of community control under the drug court docket, under those conditions that the court has previously approved and that you have received and acknowledged received. And you're required to comply with all those conditions, and then these additional conditions that they're mostly in it, but I'm going to go ahead and put those on the record. First of all, your bail laws, all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed, be truthful in all statements you make to the probation department, as well as any answers you give to them about questions they ask you. You're to keep them informed of your residence, place, and employment at all times, may not change either without prior permission. You may not leave the state of Ohio without prior written permission. If you do, you must have that with you at all times. You're not permitted to enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate in any way with anyone who is an inmate or prisoner in any of those facilities without prior written permission. You may not purchase, possess, own, use, or have under control any firearm, ammunition, or dangerous ordnance because of your conviction. And you're not permitted to have any of those while under supervision in this case, or any other weapons. You may not purchase, possess, use, or have under control any kind of a controlled substance, drug abuse, CBD, oil, kratom, any other variant or analog of a controlled substance, drug abuse that has effects similar to those, nor any instrument, device, or thing that may be used to administer drugs or prepare them for administration or use, unless you have a lawful prescription for both the device or equipment and the substance. And you must provide a copy of that within 24 hours of receipt. You may not obtain a medical marijuana card while in the drug court docket. You're to submit to drug testing when and as requested. You may not purchase, possess, use, or have in your control any alcoholic beverage, nor may be present in places where they're sold or being consumed, even if that is otherwise lawful. You're not to associate with anyone who's a co-defendant in this case, or any other person has a criminal record, is a member of a gang, or any other criminal group, or any other person who has in the past or could in the future influence you to commit a violation of these conditions, unless you have a lawful prescription, unless you have written permission from the probation department. Obviously, it doesn't apply when you're in groups and meetings and so forth, drug court, but other than that, on your own time, that's what it means. If you are referred for an evaluation or assessment for any further treatment, therapy, counseling, training, or programming by the treatment team, beyond that ordered by the court, you're to submit to that. And if there's any recommendation on any programming, you're to enroll in and follow that during the pendency of this action. You'll be required to pay the court costs and make payment arrangements to do this. And you're to make restitution in the amount of $1,107 to Justin Cutler through the victim restitution escrow account, pay service fees for that, and then as a condition that you make monthly payments on that. We'll leave that up to the probation department because while you're in residential treatment, until you get to the point where you're ready to be employed, obviously you're not going to be able to do that, but once you get that point, you will be. It'll have to be done within the 3 years. You'll be required to comply with all conditions that I haven't mentioned that are in the program description that you've received. Those are incorporated by reference into this order, and comply with all conditions or all treatment plan recommendations from your treatment plan, from the treatment team, I should say. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, rather than property places under your control where you're found at any time, any officer of the probation department. There will not be a fine or any suspension of driving privileges. Now, you're ordered, as I said earlier, to make a restitution amount of $1,107 to Justin Cutler, and that's a substantive order as well as a condition of the community control. You're ordered to pay the court costs and pay those as a condition, but you're also, that's a substantive order. If you don't make payments, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do community service and give you credit for each hour you work in an hourly rate set by the court. Each hour you work would reduce your judgment by the hourly rate set by the court until paid in full. Now, in the event the probation department feels that you're not compliant with these conditions or the treatment plan, they will file a written notice out with the court. There will be a hearing. You'll be entitled to have an attorney. The outcome of that hearing is that you have failed to comply, then at that time the court can revoke your community control and sentence you to a period of between 6 and 24 months incarceration, fine you $5,000. Should you be sentenced to prison to serve that sentence, upon completion of that prison term, it is possible the Adult Parole Authority will put you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised on the terms they set, and if they found that you were not compliant, they could return you to prison and make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of the prison term for all violations, but if you commit a new felony, then additional whatever sentence a judge in a new case can impose upon you. That judge could also sentence you for committing that offense while under post-release control in this case to an additional, to additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively as sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
There you are.
All right, that completes your case, Mr. Nisley. You're no longer under pretrial supervision conditions. You report to Ms. Sturgill over here for transfer to the drug court supervision. And Ms. Happer, if you want to get these back for her.
Great, thank you.
All right, and I think you have a Zoom coming up here in, well, about any time. It's set for right now. We'll go ahead and let counsel stay here.
Recording in progress.
All right. This is case number 22 CR103. State of Ohio versus Bradley Hixon. And you're Mr. Hixon appearing from the jail, is that correct?
Yes.
All right, Mr. Hixon, this was set up as a Zoom hearing. We're running a little bit behind this morning. Your attorney is present in the courtroom, Catherine Hafner. Also representing the state is Assistant Prosecutor King. Now, Ms. Hafner, is your client willing to waive his presence in the courtroom and agree to this by Zoom?
Yes, Your Honor.
You're all right with that, Mr. Hixon?
Yes, sir.
All right. Is there any need for you to communicate about anything that you're
No,
aware of?
I'm caught up to date on what's been going on.
And you're all right? You need to talk with her about anything?
No.
All right. The defendant has entered a plea of guilty to, for some reason I don't have any information here. All right. This was a probation violation. Defendant had originally been convicted back on January the 4th of 2023 on, I believe, aggravated trafficking in a fentanyl-related compound. Yes, 4-3 felony. That was actually pled on November 17th, 2022, sentenced on January 4, 2023. The defendant has acknowledged violating the conditions of community control as notified on October the 5th. He was before the court on October the 6th for notification. It was set, and we had the evidentiary hearing on the 27th, and he acknowledged the violation, and the court set the matter for disposition today. All right. Anything from the state, Mr. King?
Yes, thank you, Your Honor. The state and the probation department are still asking that the defendant be continued on community control and also ordered to complete the STAR program. There is a bed available at STAR on November 15th. The reason we didn't proceed to disposition back on October 27th was because the defendant had a probation violation pending in Greene County. It's my understanding that he was found to have violated his probation and that Greene County ordered him to complete what they call the Green Leaf program. My understanding of that program is that it's a 6-month program, but it is not a lockdown facility. And given that this defendant has already walked away from treatment in the past, the state and the probation department have some real concerns with the defendant going to another program that he can walk away from. So based upon that, we would request that he be ordered to complete STAR. Thank you, Your Honor.
Sam?
Thank you, Your Honor. We would also ask that he be continued on community control. Obviously, he would prefer a non-lockdown program, and that's what the Greene County Court has ordered him to complete. I do understand the state's concerns, but ultimately, we ask that you continue him on community control.
Mr. Hixon, have you anything you would like to say?
No, Your Honor.
All right. Probation Department did provide me a copy of the entry from Judge Tornicio in Greene County, indicating that it was signed on the 2nd of November that he's to continue with completion of the Green Leaf program. That it's the court's concern is, as indicated, that's not a lockdown program, and so the court's order is going to be that community control be continued under the condition that he successfully complete, additional condition, successfully complete the STAR program and aftercare recommended by the STAR program, and remain in jail until the bed is available, which is November 15th, at which time STAR will pick him up and convey him to the facility for the treatment. I'm a little confused by this order because it says that the affidavit was withdrawn in that case, alleged violation. His bonds were discharged, but then he was remanded to custody to serve the jail sanction. Do you have any more time in Greene County you have to serve, Mr. Hixon?
No, I believe Greenleaf is part of the jail. It's in the jail.
You know, I think you're right, but it does say that there's a, oh, okay, it says 6-month jail sanction to await a bed date. Okay. Well, who had him first? Did we have you first, or did you come here first, or they go to you?
Technically, I was there and then out on bond and then here.
And then here. So
Yeah.
technically, we had your body before, that we have control. Okay, well, I'm going to leave the order as the same. If there's a problem between the two counties, then I'll have probation. Mrs. Kelly, if you can contact their probation department and ask them if they would accept him going to STAR instead of their program. I would think they would, knowing Judge Tornicio. And like I said, I believe it is a jail-based program, and so he's going to be in custody, and I think that's what they were concerned about. I think STAR will still take him, but if that's a holdup, then we'll need to, but contact the officer up there and then let me know.
Yes, sir.
All right, thank you. Anything further?
No, Your Honor.
All right, thank you. All right, Mr. Benner. Nope. Well, they've never come back on. So, tell him don't be hearing from the director, because I'm going to send the director a letter. I'm tired of this crap. Yeah. All right, this is case number 08CR 2004, State of Ohio versus Dwight E. Benner. Appearing on behalf of the state is Assistant Prosecutor King. Appearing on behalf of the defendant is Jacob Wagoner. And are you Dwight Benner?
Yes, I am.
All right, the defendant has entered a plea of guilty to non-support. This is a very old case, 15 years. Mr. Benner was just recently located and served and then brought before the court at that time. The court ordered a pre-sentence report, and if each of the attorneys had an opportunity to review a summary of that report.
State has, Your Honor.
I am not, Your Honor. I apologize. I was wrapped up in Mrs. Bruns' ILC, so if I can get Mr. King's.
Yes, I'll provide that.
Thank you.
Huh? Yeah, I know.
I'll take responsibility for that, Judge. I was wrapped up in the other case, not the court staff's fault.
All right. Well, the report indicates there is an arrearage of $40,158.19. I imagine the children are long emancipated, but the arrearage is still there. All right, Mr. King, anything on behalf of the state?
Only was contained in the plea agreement, and as the court's already indicated, the total arrearage is $40,158.19. That's all.
Mr. Wagner?
Better stand up. Thank you, sir. Your Honor, in speaking with Dwight here this morning, which I'm not aware of this type of facility, but I'm aware of what it kind of sounds like, the Shawnee Family Health Center. It almost sounds like kind of what we have like for the contempt cases like Ohio Job Works or Works First. He's indicated he's hooked up with these individuals. They're helping him fill out multiple applications. They're going to help provide him transportation. Point being is, obviously in a case like this, we're not so worried about staying clean as much as getting a job to pay down the arrearage. So it appears that's where he's at. Obviously he's leaning on help from a lot of other people. He's indicated the gentleman that brought him here today is his landlord, I believe, who was gracious enough, and thank you, to bring him to court. So I think he's with limited means, but he's reaching out to the resources necessary, Your Honor. Thank you.
All right, Mr. Benner, anything that you'd like to say?
No, I'm trying.
All right, well, you can be seated. Yeah, I see a lot of these cases with large arrearages, and unfortunately, in many cases, a lot of it could have been prevented if the person that owed the money, that'd be you in this case, had simply communicated and filed the paperwork with the agency. A lot of times those amounts can be reduced, but instead you just don't pay and you let it run, and you know, it's kind of like a credit card. You just get more and more and more behind. So unfortunately you didn't do that, so the arrearage is what it is, $40,158.19. So it is the order of the court that you be placed on community control for a period of 5 years, since there's so much owed. That's the maximum. Under the supervision of the probation department, under these conditions, you obey all laws, rules, and restrictions, conduct yourself in law-abiding manner at all times, report when and as directed, may not change your address or employment without prior permission of the probation department, you may not leave the state of Ohio at any time without prior written permission, you may not enter upon the grounds of any correctional facility or communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior permission in writing. You're not permitted to possess, purchase, own, use, or have under your control any firearm, ammunition, dangerous ordnance, or any other weapon. You may not purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any of the substances like that have similar effects. You're not permitted to have any instrument, device, or thing that may be used to administer those unless you have a prescription for both the substance and the device. You must provide copies of any lawful prescriptions within 24 hours of receipt to the probation department. You're submitted to drug testing when as directed. You may not purchase, possess, use, have under your control any alcoholic beverage, nor may be present places where they're sold to be consumed, even if it's otherwise lawful. Not to associate with anyone who has a criminal record, a member of a gang or other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another person without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. Provide your supervising officer with financial information records so that your ability to pay any fees or costs can be reviewed, as well as pay the child support. If you're referred for evaluation or assessment for further treatment, therapy, counseling, training, and programming, then you're to submit to that. If there's any recommendation for treatment or programming, you're to roll in and follow that during the pendency of this action. You're also required to pay the court costs, make payment arrangements to do this. Special conditions are you're to seek work and obtain employment when offered. And you're to pay the restitution in the amount of $40,158.17, I think it is.
19, Your Honor.
19. And is that all due to the agency?
Yes, sir.
Okay. To the Highland County Child Support Enforcement Agency. And you're to make payment arrangements to do that. That's a substantive order as well as an order or condition. Now, by being placed in community control rather than being sentenced to incarceration, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property place where you're found under your control at any time, any officer of the probation department. Now, in the event that probation feels that you have failed to comply with these conditions, they'll file a written notice of that with the court. You'll be given a copy of that at the outcome of a hearing and have the opportunity for an attorney. And if the outcome of that hearing is that you have failed to comply, then at that time, the court could revoke your community control and sentence you to serve 6 to 12 months incarceration. Should that be to a facility under the Department of Corrections, Rehabilitation and Corrections, upon completion of that sentence, it is possible the Adult Parole Authority will put you under post-release control supervision for a period of about 2 years under the terms they set, and if during that period of time they determine that you have failed to comply, then they could return you to prison and make you serve an additional period of up to 1/2 of your prison term for 1 or more violations. However, if you commit a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
No, sir.
All right, this completes your case. You need to report down to the probation department, which you know where that is, 117 East Main Street, and so they'll transfer you from pretrial supervision to the supervision in this case. All right, thank you.
Thank you, Your Honor.
yeah, those can all go downstairs. All right, this is case number 10, CR 11, State of Ohio versus James A. Blain. This is a request for the sealing of a record. The state's represented by prosecuting attorney Collins and assistant prosecutor King. Defendant's represented by attorney Catherine Hapner. And you are James A. Blain?
Yes, sir.
All right. Now, the counsel for the state, has the victim or representative of the victim been notified of the time, place, and purpose of this hearing, the right to be heard?
They have, Your Honor, and Scott Graham, the current pastor of Good Shepherd Church, is in attendance and does wish to speak when at the appropriate time. Other members of the church also are in attendance but are not going to be speaking.
All right, thank you.
Sure, so in here, I remember getting it for you.
It's in the bottom drawer. I'm sealing the record.
Yeah, I don't see it.
Can't find it. Okay.
I'll keep on.
All right. All right. The motion, let's see, I'm going to have to find a motion here. I looked at it yesterday, but I didn't mark it. All right. The motion to seal this record was filed on September 22nd by Ms. Hapner. So, Ms. Hapner, you wish to make an opening statement regarding this?
Yes, Your Honor. Your Honor, this case arises from 2010, so it's not quite 15 years old, but quite an older case. Mr. Blain was convicted. He did serve time in prison. He was granted judicial release. During his time in prison, he was basically a model inmate. He completed classes. He became a tutor, tutoring other inmates. And there were no tickets, no infractions. He was granted judicial release. Since being released, he has, once again, been a model citizen. He has not had any run-ins with law enforcement. He is, once again, a pastor at a church. He continues to visit inmates both in the prison system and in some of the county jails. He does tutoring, mentoring, counseling with them. He has paid his court costs. He has completed everything except completing the restitution. He did sell, my understanding was real estate that he owned, and those proceeds all went to the church as part of his restitution. I believe his restitution order was $25 a month. He did make large lump sum payment on that when he sold that property. He is a veteran of
So is there still restitutions?
There is still restitution
Okay.
outstanding. He is a 20-year veteran of the United States Air Force, and at this point in time, it is difficult for him for housing. I said, my understanding, he sold the real estate that he owned, and he rents a place, but he's been informed that because of this conviction, he may no longer reside there and has to find new housing, and that is very difficult with this conviction. So we do believe that there is no longer any interest in justice in having this conviction held, outstanding. Mr. Blain is now in his 70s. He had, prior to this, 6 decades of being a good citizen. Since his release, he's got a decade, almost a decade and a half of being a good citizen. This is an aberration, and he has taken responsibility for that. Because of his age and the fact that he does not own his own real estate, he has to rent, this conviction does make it very difficult for him to find that place. He is a pastor again, but he cannot find any other employment. And so his duties as pastor do not pay him enough to cover all of his living expenses. He does have his Air Force retirement that he receives, but his concern is that without having housing, or if he has to pay a premium for that it makes it very difficult. And we just don't think that there is any, at this point, any benefit to the state of maintaining this conviction. And so we do ask that it be sealed.
All right, any statement from the prosecution?
Yeah, Your Honor, a few. I did file a memorandum objecting to the sealing of this record.
When did you file that?
I'm sorry?
When did you file that? 'Cause I haven't seen it.
A week ago, 2 weeks ago?
Well, maybe. Oh, here it is, I'm sorry.
October
Yeah,
24th?
I did not see it yesterday when I went through the file. Okay, I see it. Go ahead.
Okay. He does still owe $72,867.15 in restitution. Ms. Hapner is correct. The victim did receive some money from property that was sold, but it's not exactly accurate that he sold this property and then voluntarily brought a check in to pay restitution. There was actually a lien filed against the property on behalf of the victims in order for them to get that money. That's one thing I'll note. I'll also advise...
That was through the civil case? That was through the civil case?
It was through... I thought it was through this. No, I'm sorry. It was through a civil case.
Yeah, there was a civil case that was filed, as I recall. Go ahead.
And that money was taken out of the restitution that he owed. I will also note a couple other things. He has advised Ms. Collins, the director of the Victim Witness Office, that he's not paying anymore because he thinks that he has paid enough. He is also, a few things I read his PSI summary, and I remember this case well. I actually was with law enforcement when they did the search warrant in this case. While he appeared to do very well in prison, one thing that is a repeated problem, and was a repeated problem in this case, something that it was glaringly obvious, is that Mr. Blain didn't exactly take responsibility for his actions at any point during this case. And even in prison, he was recommended to do Thinking for a Change and victim awareness programs, and he didn't participate in either one of those. So while he did good things, he did what he wanted to do and not things that put him in a position of being sympathetic to his victims or acknowledging that he had victims. I'm not sure I've ever seen in a PSI or anywhere else, and this is his own statement, not the probation department's, but that he was highly rated as a model or an ideal probationer. I didn't know they did such a thing at our probation office. He indicates that he was released early by this court because of both from probation and incarceration because of his ideal behavior. I know that the court would not have necessarily released him, or in the past that's been the practice of the court, had he had a lot of infractions in prison, but there was actually an agreement by all parties involved that he get judicial release. And that's absolutely the court's decision at the end of the day. But I don't think that he got released early because he was a model prisoner. The court didn't pull the file and say, well, you're doing such a good job, let me release you early. He indicates in his statement that in 2009, he paid the Good Shepherd Church the restitution requirement 25 years in advance with the understanding that because of his age, this would be the final payment. The church representative was in agreement with this. I would love to know the name of this person that agreed to this, because it certainly wasn't the Victim Witness Office, and it certainly was no person that we have dealt with at the church. And they don't have the authority to do that. That would have had to come back before the court and the restitution be removed if that were going to be the case. He notes, it should be noted here that the church and the church board never wanted this action to go forward. It was started by a small disgruntled group of parishioners. That is not accurate. I remember dealing with the group, the members of the church board in this case, and that is just not accurate. I would say that there were a small number of parishioners that didn't want the case to go forward, but the majority of them wanted it to go forward. And several of them that were members of the church back then are still members of the church today and are here in protest of him getting his record sealed. Those are just a few things I noted in his PSI. He just continues to not take responsibility for what he did. Additionally, as I pointed out, both in my memorandum, and it's been stated on the record, he still owes over $70,000 in restitution in this matter. He makes no attempt to pay anything on it, feeling that he's just paid enough. He makes allegations about Mr. Grandy telling him this case will be completely done within 3 months. I don't remember Mr. Grandy ever actually talking to Mr. Blain, as that would have been a violation, as he was represented by competent counsel at all stages of the proceedings. The court ordered him to pay restitution in the amount of $267,000 plus at his sentencing. And we had several hearings after that to reduce the restitution and get the restitution lined up to what it was finally ordered to be. I don't believe that he is rehabilitated at all. I believe that he still poses a threat if this is continued, or if this is sealed, because he's not somebody that has any any true, genuine remorse for what he's done. And with that, I would ask the court to hear from Pastor Scott Graham.
Well, I'll do that at the appropriate
Okay.
time. My question then is there any evidence that's to be presented in the matter? Ms. Hapner, do you wish to present any evidence?
Your Honor, I'll call Jim Blain.
All right, and then I'll give you the opportunity after that. All right, Mr. Blain, if you would take the witness stand, please. Would you raise your right hand, please?
Yes,
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Have a seat right there, please. Pull that board over there to your left that's got the microphone on it, just all the way toward your left, please. All right, you may inquire.
Thank you, Your Honor. Jim, will you tell us your name and address, please?
Sure. James Blain. I live at 988 Sulphur Spring Road in Chillicothe, Ohio.
And do you own that property?
No, that's rented.
And is that a home, an apartment?
It's an apartment.
And how long have you been living there?
Approximately 2 years.
Has there recently been an issue with your residency there?
Yes.
And can you tell us what that is?
The problem is they don't want felons in there anymore.
And have you been given notice that you need to leave that property?
It's under review. I've appealed it.
Okay. So I'm going to back that up again for just a minute. If I understand you correctly, they did give you notice that you need to leave and you appealed that notice.
The problem was I lived in a former parishioner's home, and he owned the home, and his daughter decided she wanted to get married, and I had to leave that home. And it was almost impossible for me to find someplace to live.
And that was prior to where you live now?
Yes.
Okay, go ahead.
And so I finally ran into this gentleman, and we talked and discussed this, and he agreed to give me the apartment. So that's how I got into this. It was very difficult. Nobody in Chillicothe wanted to rent to me.
And you're currently a pastor at a church, is that correct?
Correct.
And what is the name of that church?
West Pleasant Hill.
I'm sorry?
West Pleasant Hill Church.
Okay, and that's over near Chillicothe?
Yes, it's closer to Logan.
Okay. And that's why you live over there as opposed to Greenfield or Hillsborough or Washington Courthouse or something?
Yes.
And you've not been able to find any place else to live over there?
Not yet.
Okay. Now,
actually, I was contemplating moving to Texas to be near my son and my grandchildren. But I'm fearful to make that jump because I don't know if I'll be able to find anything down there because of this record.
Gotcha. So, when this case arose back in 2009 or 2010, you were the pastor at the Good Shepherd Church in Greenfield.
Correct.
And do you recall who the board members were at that time?
There's a listing on that letter. I can't.
May I approach the witness, Your Honor?
You may.
Take a look and see if I can refresh your memory as to who the board members
Yes. Should I read these? This is the list of board members at that time that wrote this letter. It was Howard Van Dyke, Roger Stevenson, Anita Stevenson, Norma Van Dyke, Michael Reinhardt, Reverend Blain, and Mary Baxla.
And the Reverend Blain, is that you or is that your son?
My father.
Your father, okay. Just making sure it wasn't you, that you didn't.
No.
Okay. And your understanding of the situation in 2009 was that the board did not wish to go forward with criminal charges.
Right. They wrote this letter.
I don't see the relevance of that, and I'm on a limited time here, so let's talk about why the criteria in 2953.32D, those are the factors I have to consider.
Sure. Then I would also ask that the state be limited and not be able to address that either.
Pardon me?
Then I would ask, because Mrs. Collins addressed that in her opening statements. That's why the only reason we were addressing it here.
Well, it doesn't really matter to me. As I recall, there were people in the parish or in the church that supported him, and there were those who did not. And
That's fair enough.
I'm very familiar with this case. So
We just want to make sure that that's before.
yeah, that really doesn't matter in the court's judgment in this issue.
Okay, fair enough. So, Jim, at some point, you were convicted of this case, in this case, and went to prison, correct?
Yes.
And how long did you serve in prison?
4 years.
4 years? Okay. And during that time, did you incur any infractions while in prison, getting tickets?
No, none.
And you took some classes and did some things and got some certificates, including the detour program, the Cage Your Rage, and the peer literacy tutor training, is that correct?
Right.
And you also were a blood spill hazards cleanup trainee.
Right.
Okay. There were recommendations that you take a couple of other classes, the Thinking for a Change and the Victim Awareness programs. Did you participate in those classes?
I was unable to because of the line. I got out before my name came up to take those classes.
So
there's a waiting period for all of those classes.
So you registered for them, but you were released before that came
Yes.
up? Okay, gotcha. So it wasn't that you just refused to participate?
No, I never refused to participate in any of it.
And it's my understanding that there was a civil case and a civil judgment against you regarding the same amount of money,
Yes,
and that civil judgment is still outstanding.
yes,
In other words, the victim in this case has other recourse other than just simply this case remaining on the books,
yes.
because they have a judgment against you. Okay. And can you tell us what you currently do, sort of community service projects, things that you do?
Most of it involves family counseling, the church, dealing with the church, marriages, funerals.
And then you're cleared to visit at several correctional institutions, is that correct?
That's correct.
And do you actively visit at those institutions?
Yes, I have a prison ministry at London every 2 weeks.
Okay, good. And you've had interactions with the federal government as far as getting your aviation license and your TSA pre-check program?
Yes. Both of those responses were favorable.
Now, Mrs. Collins stated that you said that you were not going to make any more payments on restitution. Is that correct?
That is not correct.
Can you please tell me what your feeling the restitution is?
The individual that met with me concerning this was Lanny Bryant. I wanted to sell this property, and of course they had the lien. And so I met with Lanny Bryant and I discussed it with him, and I said, look, I'm paying you $25 a month. I'll sell this property and give you this money, this block sum, as prepayment. And we sat down, we figured it up. It was 25 years in advance. And I said, do you realize, Lanny, that 25 years from now, I may or may not be alive. If I'm alive, we'll resume the payments. If I'm not, this is probably the final payment. And he said, the church can use the money now. That's quite all right. And so that was the agreement we made. And Lanny has spoken. He started this issue and has spoken for the church entirely. My dealings with this whole thing has been through Lanny Bryant. And there was a written document that the church should have about that.
But you never told anybody at the victim witness office that you weren't making any more payments?
No, no. In fact, I addressed that issue with him, and he said he would take care of that with the victim witness office. And since I never heard from them again, I assumed that he had.
And you don't have any personal knowledge of whether he did or not?
No, only that they have not contacted me.
Okay. So you've not had any contact from victim witness saying you need to resume payments?
No.
Have you had any contact from the church asking that you resume payments?
No.
Is there any other way that having this conviction on your record negatively affects you?
Just, the housing is a problem, getting a job is a problem outside the church. It's just there. It's always a problem. Whenever I try to do stuff, there's that problem. And I think I've demonstrated a life prior to this and after this that there's not a threat there.
And when you say there's not a threat, you're not a threat to anybody physically, are you?
No.
And do you handle finances at your
No.
church? So there's no issue or threat with you?
No.
Do you believe that it would support the interest of justice to have this record expunged or sealed?
Yes, I do. It's just continued punishment for me, and I feel like I've paid my debt to society.
I have no further questions, Your Honor.
Cross.
And at your current position, do you have access to church proceeds?
No.
You have no access to their money whatsoever?
No.
And how do they?
I maintain a strict wall.
Are they aware of your conviction?
Oh, yes.
Is that why they maintain a strict wall?
I set that up.
And you talked about this conversation with Laney, is that correct?
Yes.
And Laney's passed away, correct?
Yes.
You have proof of this agreement?
The church should have proof of that.
That's not what I asked.
I don't know.
So you entered a contract, according to you, with Laney Bryant to forgive restitution, and you didn't keep a copy of this contract?
I kept a copy of it, but when I moved,
So
that went into storage. I'm not sure where that is.
So you have a copy of it?
Yes.
So with a brief continuance, you could provide the court with a copy of what you're testifying to?
I would hope so. I don't know.
I mean, would you agree that this a contract that you say was entered into to forgive the $70,000+ in restitution that you owe? That would be pretty important, wouldn't it?
There was no mention of forgiveness.
Well, your statement is
we're
that...
We're saying I'm paying 25 years, I'm giving to you this in advance, and there may not be a live Jim Blain at the end of this 25 years. Do you want this money now?
How much money was it?
And he said $7,500, I believe, or plus or minus.
You're talking about from the sale of the house?
Garage.
Okay. Would you agree with me that there was a judgment lien placed on that?
Yes.
Okay, so that wasn't your agreement to pay, that was an order to pay.
It was an agreement because that lien died a year later. And I could have just waited a year later and let the lien die and sold it and not given them anything.
Or they could have filed a new lien.
Yes.
Okay. So, again, my question to you is, would you agree that this contract that you allege to have with Laney Bryant would be extremely important in this?
Yes. I would not call this a contract. I would call this an agreement letter.
Okay.
And a copy of that went to the church.
My question again is, would you agree then this agreement letter is extremely important in this case?
Sure.
And your statement to this court is that you have this letter?
I hope so, yes.
And how long will it take you to produce it?
I don't know. Ms. Collins, I don't know. All of this stuff went into storage when I moved.
Mm-hmm. So you have no proof of it?
Not with me today.
Okay. Were you aware by the order of your sentencing that the restitution was still due and owing?
You need to clarify that.
When you were sentenced out of this court, were you aware, did you understand that you owed restitution?
Yes, of course, I paid it.
Okay. In full? You paid it in full?
No, well, that's a silly question. I did not pay it in full.
Okay. So, and
But I did pay it in advance,
$7,500.
25 years.
Okay. So, in your opinion, do you owe no more restitution?
I will, of course I do.
Okay, but would you agree with me that you have not paid any restitution since I believe 2018? August of 2019?
That's when I made the 25-year in advance payment, yes. But if you look at that record, you'll see that my payment was consistent.
I'm looking at, okay. And so when you made the payment in August of 2019, you have not made a payment since then, is that correct?
According to our agreement, that's correct.
I'm asking a yes or no question, I'm sorry.
That's correct.
You have not made a payment since 2019?
Right.
Did you understand when this court sentenced you to pay restitution, that was your responsibility?
Yes.
So it is no one's responsibility to contact you and tell you you owe restitution. Is that correct? You were told that, correct?
You're setting aside the agreement that we paid 25 years in advance, at which time the payments would resume.
The agreement you have no proof of?
The money, they have the proof of.
Yes or no? The agreement you have no proof of?
I'm going to object to that. I believe he has answered that he does not have that agreement with him.
Yeah, I agree with that. Go ahead, move on.
Did you understand that your responsibility to the restitution was until it was paid in full?
Yes.
And you would agree that you have made no payment since 2019?
No, I would not.
I have no further questions.
Redirect.
Jim, when you say you paid 25 years in advance, you're basing that on the agreement that you would pay $25 a month, is that correct?
Correct.
No further questions, Your Honor.
All right, you may step down. Any other witnesses you'd like to present?
No, Your Honor.
All right, state have any witnesses you'd like to present?
No.
All right. Now, the court is pursuant to the statute, representative victims do have a right to make an oral statement. So you indicated there was a representative wish to state the position of the church.
Yes,
right.
Pastor Graham.
Pastor
Graham.
Okay. Would you state your name and address, please? And he's going to give you a microphone, so we'll pick it up on the, a business address is fine.
Yes, sir. My name is Scott Graham. I'm the pastor. Graham as in graham cracker, Billy's brother.
Okay.
Not necessarily, but close.
I like graham crackers, but go ahead.
There you go. I am the current pastor of Good Shepherd Church. My home address is 1660 Camlin Hill Road in Chillicothe.
Okay, go ahead.
I am the current pastor of Good Shepherd Church and have been since 2013. Since 1980, I have served in various capacities of professional ministry. I've served on the staffs of very large churches, inner city ministries, small churches, and rural churches. And even though the events related to this hearing today happened many years before my tenure, Mr. Blain has served time in probation, the remnants of these failures still linger. Rarely does a week go by that I'm not dealing with something related to this aspect of the church's past. Some people who have been affected are with us today. Many of those who are hurt, unfortunately, have left the church. Others no longer attending church anywhere, and some have even left the faith. Real, serious pain has occurred and continues to impact individuals, their relationships with each other, their relationships with me as a pastor, and the organization of Good Shepherd Church. And in many ways, that pain has also affected the Greenfield community as a whole. It's a deep, deep wound that finds itself reopening and spreading its infection over and over again. Certainly, we continue to suffer from these fraudulent acts. Financially, these failures have left the church with an enormous debt, but fewer members to service that debt. Your Honor, we'll be paying back Mr. Blain's failures for another 17 years. His fraud has caused distrust in clergy and in our church and in our community. Today, Mr. Blain is asking you to seal his records. We respectfully ask that those records not be sealed. We do not believe that Mr. Blain has been rehabilitated. You instructed Mr. Blain while in prison to write a letter to Good Shepherd Church apologizing for his failures. We received that letter, but now we question its sincerity. Mr. Blain was ordered to pay financial restitution to Good Shepherd Church at over $100,000, and he's only paid a paltry fraction of that. It appears that he stopped paying after his probation ended, and his last payment that we have is in 2019 for $45. If Mr. Blain had been repentant and rehabilitated for his crimes, we believe that he would continue to pay what was ordered. Mr. Blain has not demonstrated repentance or rehabilitation. To repent means to change direction, and although Mr. Blain is attempting to get on with his life, which we applaud, a true change of direction would include some sort of amends, to include not just financial restitution ordered by a state court of law, but restitution from the heart, a humble admittance of failure with sorrow and an intense desire to make it right. Good Shepherd Church has not seen that sorrow for this sin, nor has it seen a sincere desire to make things right. In fact, he has demonstrated a lack of rehabilitation by not paying his court-ordered restitution and has shown no intention to do so. We don't believe that he's been rehabilitated. Your Honor, my presence here today isn't about the money. It's not only about the money. Because even if no money were involved, we would be asking you to keep his record unsealed to protect potential victims. As has already been testified, Mr. Blain apparently is working with another congregation, with our understanding, without going through any kind of denominational restoration program. We have no idea how much this small group of people knows or doesn't know. He's testified they do know. But because we haven't seen any sign of rehabilitation, we're concerned that he could be doing something to another congregation similar to what has happened to us. A pastor, a teacher, has influence. And until he demonstrates that he is rehabilitated, he should not have any influence over anyone. No group should be exposed to the type of pain Good Shepherd has and continues to experience. We don't want what happened to Good Shepherd Church to happen to another group of people again, ever. Any church or organization should be able to see his crimes and he should have to explain himself. It's for these reasons that we respectfully ask that you protect potential victims from Mr. Blain and that his record remain open and not be sealed. Good Shepherd Church does remain concerned about the spiritual well-being of Mr. Blain and would feel very differently if he were to acknowledge his past mistakes and work to demonstrate his repentance and rehabilitation. Until such time, however, we continue to believe it's in everyone's interest, including Mr. Blain, for his record to remain open. Thank you.
All right. No one else that wishes to speak? All right. Anything else from the state?
Not evidence-wise.
All right. Now, Ms. Hatner, you wish to present anything else?
No.
All right. I'll hear your argument then.
Your Honor, I'm probably going to be chastised for saying this.
I'm sorry.
As
Speak up a little bit.
As I will probably be chastised by some people for saying this, but I'm going to say it because part of our Christian faith is forgiveness. And while Mr. Blain has to make penance the victim has to forgive. And I'm not seeing that here in any way, shape, or form. That troubles me. Also, the statement that people have left the church. People have left the church, all denominations, for a wide variety of things, mostly through COVID. But I don't think that we can say that people have left their church because of the actions of Mr. Blain. Maybe some have, but not a huge majority of them. Unfortunately, church attendance overall has gone down since COVID. So I think that's also another statement that is slightly suspect. It's my understanding there is still a civil judgment against Mr. Blain that hasn't gone away, probably won't go away. So there is recourse for the church to still recover their money. The fact is Mr. Blain simply doesn't have any money to give them at this point in time. He may never have it. If his record is sealed and he can gain other employment, then he would have other money to pay restitution. But at this point, he doesn't and he can't. So we do believe that it would be in the church's best interest to seal his record. Thank you.
So, Ms. Collins, are you going to speak to the state?
I'll only say one thing as to, I too had thought that our Christian faith does dictate, we even discussed this in the office, does dictate forgiveness. But with that, or and maybe this is just me, but I think that it's much easier to forgive a person when they acknowledge that they've done wrong, and when they're sorry that they've done wrong, and when they ask for forgiveness. And I am going to tell you that nothing that Mr. Blain has done since 2010 to 2023 has done any of that. He is not rehabilitated, and I would point to in the statute 295332 the things the court should be considering. Has he determined whether the applicant has been rehabilitated to satisfaction of the court? And I know the court's so familiar with this case, but I remember his attitude and his actions being exactly the same in 2010 and 2011, and then we were back here for restitution hearings in 2013 and 2016. It was exactly the same. This smug, I did nothing wrong attitude, and I am, how dare you? That's how he came across. And then today, this idea that Laney Bryant entered into some kind of an agreement with him to pay $7,500 in 25 years in advance to forgive, that was not the case. It was a judgment entry that was entered against his house that he sold. That's how they got the $7,500. There was no agreement. The reason that this letter can't be produced is because I would bet my next month's paychecks that it did not exist. And next, the court looks at something else for the court to consider, the age of the offender. And I know Mr. Blain is an older gentleman. However, he committed these crimes as an older gentleman. His age it's not a factor in whether or not he's going to do this again. The cessation or continuation of criminal behavior, Your Honor, I think the fact that he is not paying restitution is a continuation of criminal behavior. He's continuing not to abide by the court's order, albeit that he no longer can be on probation, but it's because the time ran out, not because he completed everything he was supposed to do. The education and employment of the offender, this is to me the number one reason not to seal his record. He is educated, and educated so that he knew how to do things that it took a long time to catch. Educated so that he was able to, the 17, we're going to be paying for this for 17 more years is because of the debts that he accumulated on behalf of the church that they're still paying for. And his employment, he's moved right back into the same position that he was in when he was charged and convicted of these crimes against Good Shepherd Church. And again, we don't know what that church really knows. We don't know what protections are in place, but we do know that if this record is sealed, there will be no protections in place, not for this church or any other church or anyone in the public for that matter. I think based on the fact that he has not been rehabilitated, in the other sections of the statute I outlined under D1 of 295332, I would ask the court to deny this sealing. Thank you.
All right, Ms. Havner.
Your Honor, Mrs. Collins makes statements that he is not rehabilitated, that he shows no remorse. He did write letters of apology. He did make payments. He disclosed to his current church that he has this. They took him on full well knowing that. He himself put up the firewalls so that he would not be handling any finances. So there's so much going on in my head, I'm trying to spit it all out at once. He is not a threat to people. This is not a crime of violence. This is not somebody who's, a minister, and we hear so often about diddling with little kids. These are financial crimes, and are they acceptable? Absolutely not. We're not trying to say that they are. Mr. Blain has at no point said, in fact, his testimony was that he understands that there is still outstanding restitution. And he would like to pay that. He simply does not have the resources to do that because he cannot gain employment because of this conviction on his record. So we would ask that that be sealed, and we do believe it has benefits. It is not up for Mrs. Collins to say whether he is rehabilitated or not. We don't know that. You don't know that. I don't know that. She doesn't know that. That is in his heart and his soul, and that may never be known. But he has done what he was ordered to do and has acknowledged that the restitution has not been paid in full. He didn't come in here and say, oh, I don't owe another penny. He acknowledged that and would like to pay that, and we can do that by expunging this record.
All right, thank you. All right, well, pursuant to section 2953.32 D1 of the revised code, there are a number of factors to be considered. The ones that appear to be most relevant here, and whether under subpart C, whether he's been rehabilitated to satisfaction of court. D, if the prosecutors filed an objection, which they did. E, if the victim filed an objection. They didn't file one in writing, but then G, consider the oral or written statement of any victim or victim's representative, so that's applicable. And then F, to weigh the interest of the applicant in having those records sealed versus legitimate needs of any of the government. Court can also consider under paragraph H, his age, the facts and circumstances of the offense, cessation or continuation of criminal behavior, education, employment, and any other circumstances. A couple of things that have been talked about as I know that the defendant made a comment that he was released because of his ideal behavior from prison. I think that what I said at the time was that I wanted to see the church made whole to the extent it could. I'll grant that there was no bad behavior in prison. But the other statement that was made that is simply not right and is a misrepresentation, as you told the probation officer who compiled the report, he was released from incarceration and probation because of his ideal behavior. Well, I kept him on probation as long as I could, and for 5 years. And if I had the power to continue it, it'd still be on community control because of the restitution has not been made. So that's concerning. The other thing that's concerning is the fact that, and I made this note in an entry that was filed on August 15, 2013, regarding the defendant's request to have a resentencing, which was denied. One of the things I noted at that time, and I think that that continues here, is that he had not shown any remorse for his criminal acts. He continuously tried to portray himself as a martyr who pled guilty only to stop harm to the cause of the church. And he admitted he had sent letters, and I put in here in that last sentence on that page 2 of that entry, his apologies have been very, very carefully worded in the court's judgment to avoid acknowledging the fact he did commit the offenses of theft and forgery of signatures of officers of the church. And I still continue to see denial, and the whole thing and the whole approach that Mr. Blain has is this is all about me. It's not about my victim, and that's the problem. In terms of being forgiven, my understanding, and I'm a Christian, I'm not the best Christian around, but in order to be forgiven for my sins, I have to request forgiveness, and I have to admit those sins. And this is not a religious decision by any means in this matter, but in terms of chastising the church for not forgiving, I don't see that there's been a sincere request and acknowledgement of what he did to them. There's certainly not been any atonement. And so the attitude of the defendant convinces the court that he's not been rehabilitated. And I think the victim's concerns are legitimate. We still have, and the other thing I'm going to say right now is, as a general rule, it's not the law, but as a general belief of this judge, that people don't have their records sealed if they owe restitution or court cost, unless the court waives the court cost. In terms of any alleged forgiveness of any restitution obligation, that has to be by the court, not by any representative or alleged representative of the victim, particularly when that person is deceased and there's no copy of it. And even if the church had agreed to it, it would still require court approval, which is never sought. And had it been sought and the victim had agreed, I most likely would have approved that, but that was never done. In terms of the interest of the victim, I think that the concerns are the same that the court has. Next to close family members, parent, child, grandparents, siblings, in my judgment, my 72 years, almost 73 on this earth, people trust and put their trust in pastors more than any other person. And unfortunately, that's often misplaced. In this case, there was a terrible betrayal of trust. And had Mr. Blain taken the position, I did this, I'm responsible, it's my fault, I'm going to make payments, I asked for forgiveness. And I haven't seen that from him at any time. And I haven't seen the behavior that convinces me that he has any remorse for anything or anyone other than himself. I think he's very selfish, and I understand he's been a pastor all this life. I'll say right now, being a pastor don't mean you're a good Christian. I know a lot of pastors that aren't. I've had more than one member of the clergy sit right where you are. There have been more than one sent to prison. And in my lifetime in this business as a prosecutor, it's probably in double digits, if not, mid-double digits. Unfortunately, that relationship is one that many people exploit. And you didn't show any desire to ever change course, and that's one of the reasons I prohibited you from being a pastor in the church for as long as I could, because I have the same fear that was expressed by Pastor Graham, is that you would take advantage if you had the opportunity. And so, based on that, there's no restitution still outstanding. I think the lack of rehabilitation, the interest of the victim, and I think that it's the interest of the government, because I think it's important that those records be maintained, because if there should be an investigation, I would like to see future crimes deterred. And so hopefully any future church that he might be affiliated with, or any business that he might be affiliated with that would be in a position potentially and trust him with handling funds, should be able to take a look at this case and see the factors. And so, because I think that's in the government's interest, because it help prevent future crime. And so, based upon that, and again, the court finds that there is still restitution owed in the amount stated. So based on that, the court denies the motion. And I'll prepare the entry. Thank you.
Please rise.
Mark Yonker there at the jail?
Yes.
Okay. Okay, this is case number 23 CR 152, State of Ohio versus Mark David Yonker. Mr. Yonker is appearing from the jail. His attorney is William Armentrout, appearing from his office, appearing from the prosecutor's office, Assistant Prosecutor King. This is a pre-trial. The defendant's indicted for failure to comply, receiving stolen property, and lawful possession of a dangerous ordinance and a forfeiture. Final pre-trial set for the 15th, I believe, and the trial is set for the, can't read, is that the 21st or the 4th? Can't read my writing, of December. 21st, okay, that's according to the assignment notice. All right, now I see that the state and defense have each provided discovery, so does that complete discovery to the knowledge of the parties?
It does. That's from the state, Your Honor.
All right. And Mr. Armentrout, do you anticipate any pre-trial motions?
No.
All right, and has there been a written plea offer yet?
There has. My client's been made aware of it. He has a discovery, and I would anticipate this matter resolving through a plea.
Okay. All right, are there any other matters need to be discussed?
No. No, Your Honor.
All right, thank you. All right,
Back
Fred
out, Mark.
Whitley would be next.
Did you say Fred Whitley, Your Honor?
Yeah, but I don't see Miss Whit yet.
He pled last week. That case should be off.
Oh, okay. Oh, yeah. Yeah, I see that. I've already paid the attorney fee, or approved the attorney fees. All right. All right. Case number 23, CR 178, State of Ohio versus Norman Benson. Mr. Benson's appearing by Zoom from the probation department. Appearing on behalf of the state's Assistant Prosecutor King. Appearing on behalf of the defendant's Attorney William Armentrout. The defendant is charged with 6-count indictment, 3 counts of aggravated trafficking, 3 counts of aggravated possession of methamphetamine. This is the first pretrial. Final pretrial set for December 13th. Trial set for January 8th. See, the state and the defense of each provided discovery. Does that complete discovery as far as everybody knows?
Yes, Your Honor.
All right. You anticipate any pretrial motions, Mr. Armentrout?
No.
And is there a written plea offer been provided?
We haven't gotten that far, Your Honor.
All right. When do you anticipate that, Mr. King?
Within the next week, I'll be in contact with Mr. Armentrout.
Okay. All right. Anything else that come before the court?
No, Your Honor.
All right. Mr. Benson, stay in touch with your attorney. All right.
Yes,
Thank
sir.
you. All right. So, Mr. Armentrout, if you can come on over. Mr. King, are you going to handle the one in person, or is prosecutor?
I'll be over, Your Honor.
You have anybody else over to jail, the probation, Mr. Armentrout?
I was going to ask Eric, is Chris Pollard there?
He's in treatment.
Okay.
I've got Aubrey Utley's here and Ricky Jones.
Who else? And we're ready. Case number 23, CR 196, State of Ohio versus Aubrey G. Utley. Are you Aubrey G. Utley appearing there for the probation department?
Yes, sir.
All right. Ms. Utley's attorney is Dennis Kirk, and he is appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This hearing is being conducted by Zoom as a pretrial. Ms. Utley is charged with, looks like 6 other co-defendants in a multi-count indictment. Looks like she is charged in counts 25 and 26, trafficking in hashish in the vicinity of the school zone, possession of hashish. This is the first pretrial. Final pretrial set for December 13th, trial set for January 8th. See, discovery has been provided by both parties. Does that complete discovery as far as everybody knows?
Up to this point, yes, Your Honor.
I believe so.
All right. Do you anticipate any pretrial motions, Mr. Kirk?
Not at this time.
All right. Has there been a written plea offer provided yet?
Yes, Your Honor.
I did relay that to my client.
Okay. Are there any other matters need to be discussed then at this time?
Not from the state.
No, Your Honor.
All right. So, Ms. Utley, your next pretrial will be December the 13th. Stay in touch with your attorney, and we'll determine if this is going to be in person or a Zoom hearing, and we'll let you know. Thank you. All right. And then you have someone else? All right, this is case number 23 CR 176, State of Ohio versus Kevin Stewart. And are you Kevin Stewart appearing there from the probation department?
Yes, I am, Your Honor.
All right, this is a hearing being conducted by Zoom. The state's represented by Prosecuting Attorney Collins, appearing from her office, appearing from his office is Attorney Dennis Kirk representing the defendant. This matter is set for pretrial. Mr. Stewart was charged with 6 other co-defendants. I do have a plea of guilty form here, which indicates Mr. Stewart is going to plead guilty to count 43. He's charged with counts 43 and 44. All right. Mr. Kirk, are you and your client both in agreement that this matter can be conducted by Zoom rather than in-person hearing in the courtroom?
Yes, Your Honor.
And you're all right with that, Mr. Stewart?
Yes, sir.
All right. If you would need to talk to your attorney during this hearing, let me know, and I can put you and him into a breakout room where just be the 2 of you on the screen. No one else will be able to see you, hear you, and the officer will make sure no one else is listening.
Okay, Your Honor.
All right. So, Mr. Stewart, I have this plea of guilty form. Says you're going to plead guilty to count 43. I'm going to hold that up to the camera, and it has the case number, your name, plea of guilty.
Yes,
do you see that?
Yes, I do.
And you recognize that?
Yes, I do, Your Honor.
All right, and on page 3, there's about a quarter of the way down, there's a sentence that reads, I enter this plea voluntarily. Immediately below that appears to me to be the signature of Kevin Stewart, and I'll hold that up and ask you if that is your signature right there.
Yes, it is, Your Honor.
When did you sign this, Mr. Stewart?
Yes.
When did you sign it?
Oh, today, Your Honor.
All right, before you signed it, did Mr. Kirk go over it with you and explain everything to you and answer any questions you had?
Yes, he did, Your Honor.
Do you feel that you had enough time to fully consider the matter before making this decision?
Yes, I did.
And did you sign this agreement voluntarily?
Yes, I did, Your Honor.
And you still want to go forward with it now?
Yes, I do.
All right, the agreement states you're going to plead guilty to count 43, permitting drug abuse under section 2925.13b of the revised code of 5th degree felony. And further states you understand that the possible punishment is 6 to 12 months incarceration, $2,500 fine, and a 6-month to 5-year license suspension. You understand that?
Yes, Your Honor.
Are you facing any felony charges anywhere else, Mr. Stewart?
No, sir.
Are you currently on probation, parole, community control, or post-release control for a felony?
No, Your Honor.
All right, now under the law, Mr. Stewart, if you should be sentenced to a term of incarceration in prison, upon completion of that term, it is possible the adult parole authority would put you under post-release control as part of that sentence, which means you'd be supervised by a parole officer in the terms they set. And if they found you had failed to comply, they could return you to prison to serve an additional period of up to half of your prison term for 1 or more violations. But if you committed a new felony, then in addition, whatever sentence could be imposed for the new felony, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. Do you understand that?
Yes, Your Honor.
Now, Mr. Stewart, the law doesn't require the court to sentence you to prison for this offense. I can impose community control or probation, which means that instead of going to prison, you would be put under the supervision of the probation department for a period of up to 5 years on a term set by the court. If during that period of time they felt that you were not in compliance, they would file a written notice out of the court, serve you a copy. There would be a hearing. You would have a right to an attorney. And if the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and sentence you to prison and fine you and suspend your license. Do you understand that?
Yes, Your Honor.
All right, now the charge of count 43 alleges that on or about December 12, 2022 in Highland County, Ohio, that you, being the owner, lessee, occupant, or person who had custody, control, or supervision of premises located at 704 Carford Pike, Greenfield, knowingly permitted the premises to be used for the commission of a felony drug offense, to wit, trafficking in fentanyl-related compound, in violation of section 2925.03A1 by another person, to wit, April Lynn Koch and Evan Scott Clay, in violation of section 2925.13B. So that is the charge of the permitting drug abuse, the 5th degree felony, the penalties I mentioned. Now, Mr. Stewart, do you understand what it is you've been accused of by the state, what they said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
You understand the possible penalties for that offense?
Yes, I do.
And have you discussed the nature of the charge, evidence in the case, possible legal issues in the case, and possible defenses you might try to raise in trial, and possible outcomes of a trial with your attorney?
Yes, I have.
Are you satisfied with his advice and competence in this matter?
Yes, I am.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you, or have you been threatened in any way to make you sign this agreement and to plead guilty?
No, Your Honor.
Now, on page 3 or 2, there are several lines that are printed bold and underlined that read as follows. Defendant shall enter a plea of guilty to count 43. State will dismiss count 44. State and defense jointly recommend community control and referral to drug court. Defendant agrees to cooperate fully against all co-defendants, cooperate fully with the task force. Is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, Mr. Stewart, under the law, the matter of sentence is up to the judge, not the parties, and so even though the prosecutor and you are both saying that you should get a sentence of community control, that will be up to the court. So if you plead guilty, I will not have to necessarily follow in that recommendation. I'll base it upon everything that's presented at the time of the sentencing. Do you understand that?
Yes, Your Honor.
Now, Mr. Stewart, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, Your Honor.
Right now, you have certain constitutional rights, you must understand, before I can accept a plea of guilty. First, you have a right to counsel. Mr. Kirk was appointed to represent you. Now, that wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So if you decide you do not want to do this, that you want to defend against the charges, he'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes, Your Honor.
Under the Constitution and the law of Ohio, you have a right to have a jury trial on this charge, in which 12 people that live in Highland County would be selected from a group of people that live in Highland County that are summoned for jury duty on your trial date. And then once those 12 are selected, the evidence would be presented, they'd be instructed on the law, and then they would decide by unanimous verdict, meaning all 12 of them would have to agree on whether the state proved your guilt. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial. In that case, you would have what's called a court or bench trial. That means that instead of a jury hearing the evidence, the judge hears the evidence, the judge applies the law, and the judge decides whether or not the state proved your guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to confront the witness against you in open court and to cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have the right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, you request the court issues a court order, it's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here. And that's the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, Your Honor.
Now, in the Constitution, Mr. Stewart, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
And now, under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been indicted. In fact, under the law, you don't have to present any defense at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, Mr. Stewart originally pled not guilty. Not guilty plea denies allegation in the indictment, denies you committed any crime, and then exercises or invokes all the rights that I've just described for you. If you change your plea on count 43 to guilty, that is a complete opposite of the not guilty plea. It admits the allegations in the complaint or in the indictment, admits that they're a crime, that you committed that crime. And that plea exercises or invokes all the rights that I've just described for you today. It waives all the rights I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but that exception, a plea of guilty, waives or gives up your right to a jury or court trial, waives or gives up your right to confront witnesses against you, to cross-examine through your attorney, waives or gives up your right to use the power of the court to compel witnesses to come to court to testify for you, the same as the state. It waives or gives up your privilege against self-incrimination, because if you say you're guilty, that's what you should find you guilty. It waives gives up your right to confront witnesses in open court, cross-examine through your attorney. It waives gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It waives gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal you think you could have had up until this point in the case. Should I sentence you to the maximum sentence, or under other limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes, Your Honor.
And are you a U.S. citizen, Mr. Stewart?
Yes, I am.
Now, do you have any questions about the charge, the possible penalties?
No, Your Honor.
You understand them?
Yes, I
Do you have
do.
any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, I do.
And again, you understand that the recommendation on sentencing is not binding on the judge?
Right.
You have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand those?
Yes, I do.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea?
No, Your Honor.
Do you have any questions you'd like to ask your attorney, or anything you'd like to speak with him about before we go any further?
No, Your Honor.
And do you have any questions at all?
No, sir, Your Honor.
Right, then is it your decision to withdraw your not guilty plea and plead guilty to the charge in count 43 pursuant to the terms of the plea agreement?
Yes, Your Honor.
All right, then as to the charge, which reads that on or about January 9, 2023 in Highland County, Ohio, you did being the owner, lessee, occupant, or the person who had custody, control, or supervision of premises, real estate, including vacant land located at 704 Carford Pike, Greenfield, knowingly permitted the premises to be used for the commission of a felony drug offense, to wit, trafficking in a fentanyl-related compound, violation of section 2925.03A1 by another person, to wit, April Lynn Koch and Evan Scott Clay, violation of section 2925.13B, the charge of permitting drug abuse, a fifth-degree felony, carrying a possible term of incarceration of 6 to 12 months, fine of $2,500, and a license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right, thank you. Court finds on this day in open court, defendant was advised of all his constitutional rights, made no intelligent voluntary waiver of the same pursuant to criminal 11. Please accept an order filed. Defendant is found guilty of count 43 as charged. Count 44 is dismissed. The court refers this matter to the probation department for a pre-sentence report. Also refers case to the drug court docket. The same bond will continue, and the sentencing hearing will be December 14th at 1 o'clock. All right, is there anything? Pardon me?
December 14th?
14th, yes.
We are not, I don't believe we're going to be here. That's our OPAA training.
Oh, is it? Okay. That's our motion date, okay. So you're meeting a week later than we do, apparently.
Yeah.
Okay. Well, okay. All right, let's do it December the 20th at 9 o'clock.
Thank you.
Okay, so it'll be December the 20th at 9 a.m. Check with Mr. Arjima there before you leave, Mr. Stewart, for appointment for your pre-sentence report.
Okay,
Right,
thank you, Your Honor.
All right, we're going to go ahead and do a plea now. Mr. Clay, he's here along with his attorney. All right, this is case number 23 CR 171, State of Ohio versus Evan Scott Clay. We're assembled in the courtroom. Present on behalf of the state is Assistant Prosecuting Attorney King. Representing the defendant is Attorney William Armentrout, and you are Evan Scott Clay?
Yes.
All right, Mr. Clay is charged along with, I believe, 6 co-defendants in a multi-count indictment. Looks like he's charged in count 1, which is a second-degree felony. Counts 2 to 13 of various trafficking and possession of fentanyl-related compound offenses. Counts 16, 17, 18, and 19, 2 counts of trafficking and fentanyl-related compound, 2 counts of possession. Counts 33 to 34 are trafficking and possession of fentanyl-related compound. 35 is a forfeiture specification. All right, the matter, this is a final pretrial, I believe, and I believe that the matter is set for trial November 20. Now, Mr. Clay, I have been provided with a plea of guilty form, which indicates you're going to plead guilty to count 1, engaging in a pattern of corrupt activity under 2923.32A1, a second-degree felony. Count 18, trafficking in a fentanyl-related compound under 2925.03A1, a fifth-degree felony. Count 33, the same offense, the same section, but it's a fourth-degree felony. And in count 35, a forfeiture specification, which would seek to forfeit property that's mentioned in that, which is a 2002 silver Ford truck. Now, this document that I'm looking at is 4 pages long. On page 4, about halfway down the page, there's a sentence that reads, "I enter this plea voluntarily," and then immediately below that appears to be signature Evan Clay. Now, did you sign this agreement I'm looking at?
Yes, sir.
When did you sign it?
Just before court.
Okay. And when you signed it, did you understand that it was an agreement to plead guilty, so there was not going to be a trial for you, and the next step would be a sentencing?
Yes, sir.
And do you feel you had enough time to fully consider the matter before making this decision?
Yes, sir.
And when you came to court today, is this what you expected was going to happen?
Yes, sir.
You're not surprised by this?
Just speak up just a
And keep your voice up if you would,
sorry.
please. Thank you. All right. Now, the document states on page 1 that you understand that the penalties for these offenses are as follows. Count 1 is 2 to 8 years as a minimum set by the judge. And under the law, for these level offenses, the Department of Rehabilitation Corrections does have the authority, if they determine that your situation warrants it, to extend whatever sentence the judge imposes by up to 1/2. And so, for purposes of an explanation, if you received the minimum sentence of 2 years, then the Department of Corrections could increase that to 3 years by adding 1 year, which is half of 2. If you got 8 years, they could increase it by 4, half of 8. So for whatever sentence that the court imposes, that's the minimum, and then they could extend it if they chose to do so. And there's also a fine of $15,000. Prison is not mandatory on this offense, but it is presumed that it should be imposed. You understand that?
Yes, sir.
Now, in counts 18 and 33, each of those are the same offense, but on count 18, the sentence is possible with 6 to 12 months and a fine of $2,500 and a license suspension of 6 months to 5 years. For count 33, it's 6 months to 18 months, which is a fourth-degree felony, $5,000 fine, and all three of those, those two, 18 and 33, have a possible license suspension of 6 months to 5 years. You understand that?
Yes, sir.
All right. Now, count 35 doesn't carry any fine or prison term, but it does require the property to be forfeited to the state. You understand that?
Yes, sir.
All right. Now, under the law, in this case, it is possible that the sentences imposed with counts 1 and 33 can be ordered to be served consecutively, meaning one after the other. So the maximum penalty for 8 years on count 1 and on count 33 is 18 months, so that's a year and a half. So it could be a maximum that's set by the judge of 9.5, and that could be extended up to 13.5. Do you understand that?
Yes, sir.
All right. As far as count 18 is concerned, I believe that's TCAP. And so TCAP requires that fifth-degree felony be served concurrently with any fourth-degree felony or greater, I believe. Now, you facing any felony charges in any other jurisdiction?
No, sir.
All right. And are you on probation, community control, parole, or post-release control from any jurisdiction?
No, sir.
Now, under the law, if you are convicted of count 1 and sentenced to prison. Upon completion of that prison term, it is mandatory that you be put under post-release control supervision for a period of at least 18 months, up to a maximum of 3 years. So what that, what that means is that you will be supervised under terms set by the parole authority by a parole officer. And if during that period of time they determine that you are that you have not complied, they can return you to prison to make you serve an additional period of up to half, or 9 months for a single violation, up to half of whatever prison term is imposed for all violations. However, if you commit a new felony, then in addition to whatever sentence a judge in the new case can impose upon you, that judge is also authorized to sentence you to an additional period of 1 year, or whatever time is left on that post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence of the new case. Do you understand that?
Yes, sir.
Now, none of these offenses are mandatory prison term. Count 1 is presumed, but it's not mandatory. Legally, it is possible you could be put under community control or probation by the court for a period of up to 5 years to be supervised by a probation officer under terms set by the court. If during that period of time the probation department felt that you were not compliant, they could then return you, they would then have the right to file a written notice with the court and serve a copy on you, and then there would be a hearing in which you would have the right to be represented by an attorney. If the outcome of that hearing was that you had violated, then at that time the court could revoke your community control and sentence you to 9.5 years in prison and fine you $20,000. Do you understand that?
Yes, sir.
All right. Now, the charge in count 1 alleges that on or about the period of November 1, 2022, continuing through May 1, 2023 in Highland County, Ohio, and as a continuing course of criminal conduct in Fayette County, Ohio, Carl Walter Lockhart, you, Charles David Howland, April Lynn Koch, and other unindicted conspirators did recklessly, while being employed by or associated with, directly or indirectly, conduct or participate in the affairs of an enterprise through a pattern of corrupt activity, and at least one of the instances of corrupt activity is a felony of the 4th or 5th degree in violation of section 2923.32A1 of the Ohio Vice Code. So that's the first degree felony. Count 18 alleges that on or about February 8, 2023 in Highland County, Ohio, that April Lynn Koch, you, and Fred E. Whitley, did knowingly sell or offer to sell a fentanyl-related compound, a Schedule II controlled substance, in violation of section 2925.03A1. And then count 33 alleges that on or about February 28, 2023 in Highland County, Ohio, you did knowingly sell or offer to sell a fentanyl-related compound, Schedule II controlled substance, an amount equal to or exceeding 1 gram or less than 5 grams in violation of section 2925.03A1 of the Ohio Vice Code. So that's the 4th degree felony. The count 18 is a 5th degree felony with the penalty of 6 to 12 months, fine of $2,500, and count 33 is a 4th degree felony, possible prison term of 6 to 18 months, a fine of $5,000. And I believe on count 1, I didn't tell you that earlier, I believe that fine is $15,000. Now, do you understand what it is you've been charged with in each of those? I forgot, I got to read count 35. And count 35 alleges that on or about, it says, I'm sorry, it does say on or about, it does say further find and specify that the property was used in the course of or intended to be used in the course of a violation of section 2923.32A1, which is count 1, or it was used or intended for use or derived from directly or indirectly, or realized through conduct the violation of ORC 2923.32A1, and any interest that you had is subject to forfeiture pursuant to 2923.32B. And that would be the 2002 silver Ford truck with a VIN number listed in the indictment. Now, do you understand what it is you've been charged with in each of those counts, what the state said you did when, where, and how they allege that you did it.
Yes, sir.
And have you discussed the nature of each of those charges, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Now, the second page of the plea agreement has a number of sentences that are underlined in bold and printed in bold, and I'll read those at this time. To finish, Your Honor, plea of guilty to count 1, count 18, count 33, and count 35. State will dismiss remaining counts. State and defense jointly recommend 3 years in count 1, consecutive to 9 months in count 18, consecutive to 14 months in count 33, for a total of 4 years and 11 months. State will not oppose judicial release to substance abuse treatment after 6 months incarceration. Defendant agrees to forfeiture outlined in count 35. Defendant agrees to cooperate fully with the task force, cooperate fully against all co-defendants. Defendant agrees to repay by money in the task force to the task force as follows: $820 joint and several with April Lynn Coke, $180 joint and several with April Lynn Coke and Sherry Lynn Nisley, $240 joint and several with April Lynn Coke and Fred Whitley, and $100 alone. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Under the law, the matter of sentencing is up to the judge, not to the parties. And so even though there's an agreement that you receive a specific sentence on each of these 3 counts that carry a possible prison term, the court's not required to follow that. I could decide, after all the evidence, to sentence you to the maximum sentence possible, fine you, and suspend your license. You understand that?
Yes, sir.
Now you have certain, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
Right now, you have rights, you must understand, before I can accept a plea from you. First, you have a right to have counsel. Mr. Armentrout was appointed to represent you. That appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you like and provide. So if you decide you do not want to do this, that you want to defend against the charge, he'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes, sir.
All right. Now, under the law, you have certain constitutional rights you must understand before I can accept a plea. First of all, you have a right to have an attorney. Mr. Armentrout, I'm sorry, I've already said that. You have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence would be presented, they'd be instructed on the law, and then that jury would decide by unanimous verdict whether the state proved your guilt on any of the 4 counts. And the verdict on each of those would have to be unanimous, meaning all 12 would have to agree. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up the right to have a jury trial. And in that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, judge would hear the evidence, the judge will apply the law, and the judge will decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have a right to confront witnesses against you in open court and cross-examine through your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney will ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court and testify on your behalf, the same as the state. So if you have witnesses you're uncertain going to come in voluntarily, at your request, the court will issue subpoenas and that's in a court order, and that would require those people to come to court to be able to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. You understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, any time. No one can even talk about it, except in one situation. If there's a jury trial, you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that The burden of proof isn't on you to try to prove that you're not guilty. The burden of proof is upon the state to prove that you are, and they must do that by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right. You originally entered a plea of not guilty. Plea of not guilty denied the allegation in the indictment, denied you committed any crime, excuse me, and it exercised or invoked all the rights. If you change your plea on these four counts from not guilty to guilty, that's the opposite of not guilty plea. The guilty plea will admit the allegation in each count, admit that they're a crime, and you committed that crime. And that plea waives and gives up all the rights I've described for you today, except the right to have an attorney. You always have a right to have an attorney, no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial. Waive or give up your right to confront witnesses against you and to cross-examine through your attorney. Waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. Waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up to this point in the case. Now, if I should sentence you to the maximum sentence on any of these charges, or under other limited circumstances, you could file an appeal. That would have to be filed within 30 days for sentencing entry being filed. Do you understand all that?
Yes, sir.
And Mr. Clay, are you a U.S. citizen?
Yes, sir.
Right. Do you have any questions about the charges or the possible penalties?
No, sir.
You understand them?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand that?
Yes, sir.
You understand the sentencing recommendation is not binding on the court?
Yes, sir.
You have any questions about the plea of guilty?
No, sir.
You understand that?
Yes, sir.
You understand all the constitutional rights I've explained?
Yes, sir.
Do you have any questions you'd like to speak with Mr. Armentrout about before we go any further?
No,
Then is it your decision to withdraw your not guilty plea to these four counts and plead guilty according to the terms of the plea agreement?
sir. Yes, sir.
All right. Then as to count one, which alleges that on the period of November 1, 2022, continuing through May 1, 2023, in Highland County, Ohio, and as a continuing course of criminal conduct in Fayette County, Ohio, Carl Walter Lockhart, you, Charles David Allen, April Lynn Koch, and other unindicted co-conspirators did recklessly, while being employed by or associated with, directly or indirectly, conduct or participate in the affairs of an enterprise, corrupt activity. In at least one of the instances of corrupt activity is a felony in the 4th or 5th degree, in violation of Section 23.32A1 of the Ohio Revised Code. The charge of engaging in a pattern of corrupt activity, a 2nd degree felony, carrying a possible prison term between 2 and 8 years as a minimum set by the judge, maximum of up to 50% of that being added by the Department of Rehabilitation and Corrections, fine of $17,000, I think, for right now, $15,000. How do you plead?
Guilty, Your Honor.
Then as to count 18, which alleges that on or about February 8, 2023 in Highland County, Ohio, April Lynn Koch, you, and Fred Whitley did knowingly sell or offer to sell a fentanyl-related compound, Schedule 2 controlled substance violation, Section 2925.03A1, charge of trafficking in a fentanyl-related compound, a 5th degree felony, carrying a possible term of incarceration of 6 to 12 months, fine of $2,500, license suspension 6 months to 5 years. How do you plead?
Guilty.
And count 18, which alleges in on or about February 8, 2023 in Highland County, Ohio, April Lynn Koch, you, and Freddie Whitley did knowingly, no, wait a minute, that's count 18, sorry. You already pled to that. Count 33 alleges on or about February 28, 2023 in Highland County, Ohio, you did knowingly sell or offer to sell a fentanyl-related compound, Schedule 2 controlled substance, amount equal to or exceeding 1 gram or less than 5 grams, in violation of Section 2925.03A1, charge of trafficking a fentanyl-related compound, a 4th degree felony, carrying possible prison term between 6 and 18 months, fine of $5,000, and a license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
And then it's count 35, which alleges that the following property was used in the course of or intended to be used in the course of a violation of Section 2923.32A1, or the property was used in, intended for use in, derived from, directly or indirectly, or realized through conduct in violation of ORC Section 2923.32A1, and any interest that you had is subject to forfeiture pursuant to ORC 2923.32B, which is a 2002 silver Ford truck with a VIN number in the indictment. How do you plead?
Guilty, Your Honor.
All right, thank you. You can be seated. All right, the court finds that on this day in open court, defendant was advised of all of his constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Pleas accepted and ordered filed. Defendants found guilty of counts 1, 18, 33, and 35 as set forth in the indictment. The remaining counts against defendant are dismissed. Now, given the nature of these offenses, the recommendation of the parties for prison term, the court does not feel that there's a need for a pre-sentence investigation, and therefore I'm going to go ahead and proceed with sentencing. So, on behalf of the state.
Thank you, Your Honor. The state would ask that the court follow the joint recommendation. The forfeiture of the vehicle listed in count 35 would be to the Highland County Task Force. Would ask that the clerk of courts be ordered to issue a title for that vehicle to the Highland County Commissioners. And finally, would ask that the defendant be ordered to make restitution as outlined in the plea agreement. That's all. Thank you.
All right, Mr. Armstrong.
I would ask the court to follow the recommendation made by the state and impose a sentence as agreed upon. Obviously, it will be very important to Mr. Clay in about 6 months' time to ask the court for an early release. I would state to the court, since the first time he was in my office a few weeks ago, made no arguments, no excuses about this wasn't him, so on and so forth, that we see his is a drug use problem and selling it goes along with it. So we'd ask the court to consider imposing the recommended sentence, Your Honor.
All right, Mr. Clay, anything that you would like to say?
No, Your Honor, I'm just ready to get all this behind me.
All right. Well, Mr. Clay, this is a significant amount of drug trafficking that's going on. A number of people were involved. And, you know, over a period of time, quite a lot of drugs are brought into the county and distributed. I know you only have one prior misdemeanor conviction, so I assume that's why the state's willing to give you a break and give you a recommendation for judicial release. And like I said, that's not binding on the court, but if you hold up your end of the bargain and if necessary testify or cooperate, you know, that certainly would go a long way toward the court following that recommendation. And so the court is going to follow the recommendation, except that because of TCAP, count 18 has to be served concurrently. But I'm going to fashion the sentence that the parties agreed on. And so as to count 1, it's ordered to be sentenced to a minimum term of 4 years, and that could be extended by a period of up to 1/2 by the Department of Corrections. So that could be a total of 6 years. On count 18, you're sentenced to a term of 9 months, which, because of the TCAP contract that we have, that must be served concurrently with count 1. As to count 33, it is ordered that you be sentenced to a term of 11 months consecutive to count 1, but concurrently to count 18, for a total term of 4 years and 11 months. Now, according to the sheriff, you have 11 days of jail time credit, so that'll be credited against that sentence. Now, if you should serve this entire term, Mr. Clay, upon completion of that prison term, the Adult Parole Authority will put you under post-release control supervision for a period of at least 18 months, up to a maximum of 3 years. And that means you'll be supervised by a parole officer on the terms they set. And if during that period of time they determine that you have failed to comply, then they will have the right to return you to prison and make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations, but if you committed a felony, then in addition, whatever sentence the judge in the new case can impose upon you, the judge could also sentence you for committing an offense under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence of the new case. You're also ordered to pay the court costs, which judge would grant an executioner's order. If you fail to do that, the court clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of the prison term, not while you're in prison, the court could allow you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. And each hour you work will reduce your judgment by that amount till paid in full. Now, it's also ordered that you make restitution to the Highland County Task Force through the Victim Witness Office and pay the service fees charged for that. And the amounts of that restitution are $820 jointly and severally with April Lynn Koch, $180 joint and several with April Lynn Koch and Sherry Lynn Nisley, $240 joint and several with April Lynn Koch and Freddie Whitley, and $100 in loan. It's also ordered that the vehicle in count 35 be forfeited to the Highland County Task Force.
Yes, Your Honor.
And clerk is ordered to execute or to transfer the title to the county. All right. Anything further, counsel?
No, Your Honor.
All right. You're remanded to custody, Mr. Clay. Thank you. All right. Who do we have there at the probation department now? Jones. He's going to go back to his office, and we'll get him hollered later after he gets back to his office. All right. This is case number 23-CR-167, State of Ohio versus Ricky Allen Jones Jr. You're Ricky Allen Jones Jr. appearing there for the probation department.
Yes, sir.
This is a pretrial being conducted by Zoom. Mr. Jones's attorney, Sarah Barger, appeared in her office, appeared for the prosecutor's office, Prosecutor Collins. Defendant's charged with aggravated possession of methamphetamine, fifth-degree felony, endangering children, a first-degree misdemeanor. This is a first pretrial. Final pretrial is set for the 13th of December. Trial date set for the 8th. I see the discovery's been provided by both parties. Is that complete discovery as far as everybody knows?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right. Do you anticipate any pretrial motions, Ms. Barger?
Not at this time, Your Honor. However, I will point out that my client has failed to contact me.
You need him to contact you?
I do.
All right. You have her phone number there, Mr. Jones?
Yes, sir.
All right. Well, as soon as you leave the building, you contact her and maybe she needs to talk to you. Has there been a written plea offer provided to you, Ms. Barger?
There has, Your Honor.
Okay. And he's not aware of it, correct?
Correct.
All right. Well, that's one of the reasons you need to get in touch with her to discuss that, to see if that's something you want to do, Mr. Jones. So you make sure you contact her right away today. All right. Anything further to come before the court on this matter?
No, Your Honor.
All right. Could go ahead and leave then, Mr. Jones. Thank you.
All right, thank you.
All right. This is case number 23-CR-145, State of Ohio versus Lindsay Brooke Adams. Ms. Adams is appearing, this is a hearing being conducted by Zoom. She's appearing on the screen that is marked Lindsay Adams. Her attorney is Sarah Barger, appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. Defendant is charged with a single count of grand theft of motor vehicle. Ms. Collins, has the alleged victim of this offense been notified of the time, place, and purpose of this hearing and the opportunity to be heard?
They have, Your Honor, and they've elected not to appear.
All right. I see that discovery looks like it's been provided by both parties. Does that complete it as far as everyone knows?
Yes. Again, at this time, Your Honor, this client has failed to contact me.
All right. Miss Adams, where are you located?
I'm currently in treatment at the Lighthouse. I tried to reach out. I called the clerk of courts and got Miss Barker's information, and I had tried to call the office, but I didn't get a hold of anybody. So I contacted my probation officer yesterday and let him know that I would be here and asked if there's anything he heard or anything that I needed to do. So I just want to make sure I have Ms. Barker's correct contact information so that I can get in touch with her.
Go ahead and give that to her.
937. 768.
Okay.
2565. If someone doesn't answer, you have to leave a voicemail with your name and telephone number, and you will get a phone call back, I promise.
Okay, all right.
All right. So make sure you do that so she can discuss the discovery with you and what discovery you might have, as well as if there's a plea offer. All right.
Absolutely.
So the next pretrial is set, I believe I said, for the 13th of December. And
Yes, sir.
Are you still going to be in treatment at that time?
Yes, sir.
All right. So we'll do that by Zoom, but you do need to make sure you get in contact with Ms. Barker. Okay.
Absolutely.
All right.
Yes,
Thank you.
thank you.
Case number 23 CR 166, State of Ohio versus Audrey V. Edwards. This is a hearing, pretrial hearing being conducted by Zoom. Mr. Edwards is appearing on the screen. It's marked TRC with other identifying letters and numbers. Her attorney is Jacob Wagner, and he's appearing by Zoom from his office. Appearing from the prosecutor's office is Assistant Prosecutor, Prosecuting Attorney Collins. The defendant's charged with one count of aggravated possession of methamphetamine, a fifth-degree felony. This is the first pretrial, final pretrial set for December 13, I believe, and trial is set on January 11. Now, I don't see any, I just see a discovery request October 6th, and I guess the state did provide a discovery. I don't see yours, though, Mr. Wagner, so yours is going to be due by final pretrial. And do you anticipate any pretrial motions?
I do not, sir. If I may address the court, we actually, and I take a little fault on this, or I guess all of it, we've got a plea worked out. My client's already answered the questions. We got the plea form signed, but I didn't file the intervention motion yet. That'll be coming over this afternoon or tomorrow, but we'll have this done here in probably a couple weeks, Your Honor.
Okay. All right. Is there anything else that needs to come before the court at this time in this case?
No, sir.
Not from this.
All right. Thank you.
Thank you.
All right. One State of Ohio versus Samuel Holliday, 23 CR 136. This is a hearing, a pretrial hearing to be conducted by Zoom. Mr. Holliday's attorney is Sarah Barger. She's appearing from her office by Zoom. Appearing from the prosecutor's office, Prosecutor Collins. Defendant is not present, and I do have a report from Mr. Arjima, which indicates that according to the Vine link, the defendant was released from Clinton County, was transferred to Clinton County on October 25th and then released from there. And he had been told to report to Holliday County, and once he was released at his arraignment, he is not. And you've heard nothing from him, Ms. Barger?
That is correct, Your Honor.
Okay. All right, so the court will issue a capias and put this matter on the inactive docket until such time as he's brought back before the court. All right, thank you.
Thank you.
23 CR 181. All right, this is State of Ohio versus Christopher Ray Pollard. You're Christopher Ray Pollard, appearing on the screen marked Chris Pollard.
Yes, sir.
All right, this is a pretrial being conducted by Zoom. Mr. Pollard is appearing from his on his phone. Appearing on his behalf is Attorney William Armentrout, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. Defendant is charged, it's like a 14-count indictment. I think it's 7 counts of trafficking and 7 counts of possession. This is a first pretrial, final pretrial set for the 5th of December, and 21st of December is the trial date. I see there's been discovery provided. Looks like by both sides. Is that completed as far as everyone knows?
It is from the state.
Yes, Your Honor.
All right, and do you anticipate any pretrial motions, Mr. Armentrout?
None that I'm aware of, Your Honor, no.
All right, has there been a written plea offer received?
There has my client.
And is your
My
client
client is
aware?
not aware of it, Your Honor.
He's not?
No.
Okay. All right, so Mr. Pollard, you'll need to get in touch with your attorney to schedule an appointment to talk with him about the case so that we'll be in a better position to know what's going to happen at your final pretrial.
Can I get his number, sir?
Sure.
Chris, do you have a number where I can reach you?
Yeah, I can give you the counseling number. That's where I'm at right now.
That's fine.
1740-354-8100.
Is that the counseling center?
Yes.
All right, thank you.
That's my case manager.
Okay.
What's his name, Chris?
Alex?
Alex?
Yes, sir.
What's his last name?
Ehivener. It's pronounced Ivener.
I'll be in touch with Mr. Pollard.
Okay.
All right.
All right, anything else we need to discuss at this time?
No, Your Honor.
All right.
No, Your Honor.
I believe that completes the docket then, except for arraignments.
That's correct, Your Honor.
All right, thank you, everyone.
Thank
Thank
you.
you.
Twenty-three CR 199. All right, this case number 23 CR 199, State of Ohio versus Sharon D. Riffle. She's appearing by video from the jail. For the record, Ms. Riffle is charged with burglary, safe cracking, and theft, and my bailiff informed me that the prosecutor had reached out to the alleged victim or victims of the charges, and that the indication was the victims did not wish to participate. And so we're going to go ahead and proceed with this arraignment. Ms. Riffle, you were charged with burglary, which alleges that on or about May 11, 2023, you did by force, stealth, or deception only trespassing an occupied structure that was a home or temporary habitation of a victim, for victim, when that person or another person other than an accomplice was present or likely to be present with purpose to commit a criminal offense. So that is burglary, a second-degree felony, carries a possible prison term between 2 and 8 years as set by the judge, with a possibility of that being extended by up to 50% by the Department of Rehabilitation and Corrections, and a fine of $15,000. Count 2 alleges safe cracking, and it alleges that on or about the same date in the same county, you did knowingly, with purpose to commit an offense, knowingly enter, force, entrance into, or tamper with a vault, safe, or strong box. That's a 4th-degree felony, carries a possible prison term between 6 and 18 months, and a fine of $5,000. Count 3 is a theft charge, alleges on or about May 11, 2023 in this county. You did with purpose to deprive the owner of property, knowingly obtain or exert control over that property, to wit, miscellaneous paperwork, U.S. currency, jewelry, and other miscellaneous items with a value equal to or exceeding $1,000 but less than $7,500 without the consent of the owner, person authorized to give consent. So that's a charge of theft, which carries a possible term of incarceration of 6 to 12 months and a fine of $2,500. Now, you are entitled to have an attorney in this matter, and if you cannot afford to hire an attorney, the court will appoint one for you. And let's see, you were in the county court previously, so let's see. All right, looks like, oh, Mr. Grandy was your attorney there. Well, I don't appoint Mr. Grandy in this court, so I'll appoint Attorney Catherine Hapner of Hillsborough, Ohio, to represent you. And in the absence of counsel, will enter a not guilty plea on your behalf. Are you being held on any other charges other than this? Do you have any other charges that you're being held on? Okay, I can't hear you. All right, Deputy, I think that your volume may not be up. I didn't hear anything there.
I'll try. I said no, sir.
Okay, all right. So you're not being held on anything other than these charges, right?
No, that's it.
Okay. Catherine Hacker.
Danielle's here at 1:30 for a video plea.
All right. All right. So we will set up a bail review hearing by video for you on Monday, the 13th. That'll be by Zoom, and that'll be at 1:15 p.m. Yeah, just leave you that, just in case. Oh, man, they give you a short trial date. All right, first pre-trial will be set for Monday, for November the 15th at, whoop, I'm in the wrong year, it's 2024. That'll be at 1 o'clock. That'll be a Zoom hearing. Final pre-trial will be December the 4th at 1 I'm sorry, December 5th. Make it December 5th at 2 o'clock. That can be by Zoom. And the trial date, well, let me refit. I can't do it that way because of the short time for trial. So, sorry about that, Deputy. Let's move the final pretrial will be November the 22nd at 9 a.m. so okay. So bond review is 11/13 at 1:15 by Zoom. First pretrial is November 15 at 1 p.m. by Zoom. And final pretrial is November 22nd at 9 a.m. And trial date will be set for December the 4th at 8 a.m. It's a pretty quick turnaround, but since you've been in jail, the speedy trial date's the 15th. That most likely is going to get extended because I doubt your attorney's going to be able to be ready by then. But we'll deal with that when we have a pretrial. Bond set in the amount of $15,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. It's also ordered you pay a deposit of $171 for the statutorily required fees prior to release. You'll be under pretrial supervision if you should make bond, and that'll be at your address at, let's see. Actually, I forgot to ask you, everything on your financial disclosure form correct, Miss Riffle?
It's Mr., but yes.
All right. All right, so you'll be required to report to probation at 117 East Main Street immediately upon your release. If you make bond, you'll report to them once a week for 4 weeks. After that, as they determine, undergo random drug testing they may order. Provide home phone numbers or telephone numbers for home, cell, and employer. Have no contact with any alleged victims. Recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatments indicated, you enroll and follow that during the period of this action. And you'll be under house arrest at your residence. And is that 1013 Spring Street?
Yes, sir.
All right. All right, and Greenfield, Ohio. That means you must be there at all times, Ms. Riffle, unless you're working, going to and from work, medical appointments, court proceedings, in this or any other case, appointments with an attorney or probation officer, in this or any other case, schooling, any kind of educational programming, church services, and any family holiday events, if there are any. You have to go directly to and from each of those places and notify probation in advance when and where you'll be going. All right, we'll notify your attorney of her appointment, and we'll have the set up. We'll have the bond review hearing Monday at 1:15. Thank you. All right. All right, are you Alan Shoemaker?
Yes, sir.
Shoemaker, you were indicted again by the grand jury on November the 7th for violating protection order consent agreement under 2919.27A1. It alleges that occurred on or about September 27th this year in this county, and that you recklessly violated the term of protection order consent agreement approved under ORC 2920.26 or ORC 3113.31 in Highland County Common Pleas Court case number 23DV-079 on June 20, 2023, that you previously been convicted of violating protection order consent agreement in Hillsborough Municipal Court on case number 19 CRB 242 on April 9, 2019 in violation of section 2919.27A1. That's a 5th degree felony, which if convicted carries a possible prison term of between 6 and 12 months and a fine of $2,500. You're entitled to have an attorney to represent you, and if you cannot afford to hire one, the court will appoint before you. I know you have appointed counsel in the other case, so I'll go ahead and appoint Danielle Witt to represent you in this case and enter not guilty plea on your behalf. Also note for the record that the prosecutor's office informed the bailiff that for purpose of arraignment, any cases that have alleged victims today did not wish to be present or participate. So we're proceeding without them or the prosecutor. Set the first pretrial in this case for November the 15th at 1 o'clock. Final pretrial will be December 13 at 1 o'clock. And trial will be set for January 8 at 8 a.m. Bond will be set in the amount of $5,000 plus your own recognizance. You must also pay a deposit prior to release of $171 for certain statutory required fees. Be under pretrial supervision of the probation department, 117 East Main Street. Report there if you make bond. You're required to report once a week for 4 weeks, and after that, as they determine, go random drug testing in the order. Provide phone numbers for home, cell, and employer. Not to have any contact with the alleged victim, Mr. Shoemaker. I'm telling you, don't reach out in any way, directly or indirectly, in any manner that might be interpreted that you're having contact with the alleged victim, because you see what happens. If they allege you did that, then you come back here. So it's up to you. You need to make sure you take every action you can to prevent yourself from being put in a position where you could be accused of further offenses. If recommended by probation, you'll be evaluated for substance abuse and mental health issues. Any treatment's indicated, then you'll enroll in and follow that during pendency of these action, and you'll be under house arrest in the same address under the same terms as set forth in your other cases. All right, we'll notify Ms. Witt of the appointment. Nah, I'm not doing that. Yeah. All right, thank you. I thought that Sheridan guy was a gal. And I couldn't answer, he didn't answer me, and I'm thinking, there's a girl. I didn't realize until he said something, and I realized, oh.
You sit right there.
All right, this is case number, well, first of all, are you Chelsea M. West, Marie West?
Yes.
All right, this is case number 23 CR 212, State of Ohio versus Chelsea M. West. Ms. West, you were indicted by the grand jury on the 7th on a charge of aggravated trafficking of methamphetamine and aggravated possession. It alleges that occurred on or about December 15, 2022. Count 1 alleges you knowingly sold or offered to sell methamphetamine on that date. Count 2 alleges on or about that date you possessed it. First count is a 4th degree felony, carries a possible prison term between 6 and 18 months and a fine of $5,000. Count 2 is a 5th degree felony, carries a possible term of incarceration of 6 to 12 months and a fine of $2,500. Both carry possible suspension of your driving privileges of 6 to 18 months. I'm sorry, 6 months to 5 years. Now, you are entitled to have counsel represent you in this matter. If you can't afford to hire counsel, the court will appoint one for you. I see you have filled out a financial disclosure form. So this indicates you're not employed, is that correct?
Yes.
All right. All right, then the court will find that you are entitled to appointed counsel. I'll appoint attorney Dennis Kirk to represent you. And in the absence of counsel, I'll enter a not guilty plea on his behalf, or on your behalf, I should say. Now, have you been previously convicted of a felony, Ms. West?
No.
Okay. All right. And then we will set your first pretrial for December the 13th at 1 p.m. Final pretrial will be January the 3rd at 1 p.m. And your trial date will be January 22nd at 8 a.m. How long have you lived at that Maribot Street address?
It's my mailing address.
I'm sorry?
It's just the mailing address where my mail goes.
Where are you staying?
It's my grandparents' house.
All right, so where would you be physically living if you're released?
814 Maribot Street, right beside it.
Okay, that's the address then, all right.
Yeah.
Well, since you don't have any previous felony convictions, I'm going to release you on your own recognizance, which is your promise to appear. And if you do not appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. Now, you'll be required to pay a deposit of $171 within 30 days to the clerk. You'll be required to report to probation department at 117 East Main Street as soon as you're released here today. And that, you know where that's located uptown here, across from Flagway?
Yeah.
Okay, you report there immediately. You're required to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing. They may order, provide phone numbers for home, cell, and employer. Not to have any contact with any alleged co-defendant. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment's indicated, you enroll in and follow that during the pendency of this action. You'll also be under house arrest at that residence at 814 Maribot, meaning you have to be there at all times. And if you are not there at all times, then you could have your bond revoked and be held in jail until further with the court. You can go to and from work, medical appointments, court proceedings in this or another case, appointments with an attorney or probation officer in this or any other case. You can go to any kind of schooling, job training, educational programming, or church services, and family holiday events. You must go, though, directly to and from those places, and you must notify the prosecutor or the probation department in advance of when and where you'll be going. And if you violate any of these conditions, then as I said, that could result in a warrant being issued for your arrest and you being held till further order of the court. All right, we'll notify your attorney of his appointment. You can also get his phone number, so forth there from the jail before you process out. Do you have any questions?
No.
All right, make sure you report to probation. All right, Elizabeth West will be next. All right, are you Elizabeth Margaret West?
Yes, sir.
All right. This is case number 23 CR 213, State of Ohio versus Elizabeth Margaret West. Ms. West, you've been charged in a 6-count indictment. It looks like 3 counts of trafficking in a fentanyl-related compound and 3 counts of possession.
Yes,
each
Your
of
Honor.
those are 5th-degree felonies. And
Yes.
count 1 is alleged to have occurred on or about February 24, 2023 in this county when you knowingly sold or offered to sell that. Count 2 alleges on or about the same date you possessed that. Count 3 alleges on or about March 5, 2023, you knowingly offered to sell or sold fentanyl. Count 4 alleges on or about March 5th of the same 2023 you possessed that same amount. Count 5 alleges that on or about March 9 of 2023 you sold fentanyl or offered to sell it in March. And then count 6 alleges on March 9 you possessed that amount. Now, you are entitled to have an attorney to represent you in this matter, and if you cannot afford to hire one, the court will appoint one for you. See, you filled out a financial disclosure form. Is everything on that form correct?
Yes, Your Honor.
Are you okay, Miss West? You seem like you're in some distress there. Are you having some problems? You feeling bad?
Yeah, I'm feeling bad.
Okay, I'm not surprised. All right. All right, the court will appoint attorney, I lost my sheet here.
Okay.
Okay, the court is going to appoint attorney Jacob Wagner to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf.
Okay.
I'm going to set bond review tomorrow at November the 9th at 1:30 by Zoom. Mr. Wagner's going to be here, so we'll do that by Zoom. Your first pretrial will be set for December 13th at 1 p.m.
Okay.
Final pretrial will be January the 3rd at 1 p.m. Trial date will be January 22nd at 8 a.m. I'm going to set bond in this case the amount of $5,000 because I think it'd be safe for you to be out on your own right at the moment, and you know, it may be that you want to reach out to one of the people in probation, the clinical people that might want to evaluate you to see if you might need to be getting some treatment somewhere. And if that's the case, I'll reconsider that. We'll also reconsider it tomorrow when we have the hearing. So for the moment, it'll be $5,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony.
Right.
You need to set up. You'll be required to pay a service fee of $171 prior to your release. You'll be under pretrial supervision of the probation department at 117 East Main Street. Report to them as soon as you're released. And we report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing, provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. And if any treatment is indicated, you'll enroll in and follow that during the pendency of this action. And you'll be under house arrest at your residence at 151 Lafayette Street, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case, go to any kind of schooling, job training, educational programming, college classes, GED classes, etc., church services, and any family holiday events, but you must go straight to and from those events, and you must notify the probation department in advance of when and where you'll be going and how long. If you fail to comply with any of these conditions, the court can revoke that bond and have you held until further order of the court. All right, you have any questions, Ms. West? You have any questions, Ms. West?
Did you keep it? No.
All right, thank you. All right, let's see. One more? All right, are you Christina K. Jenkins?
Yes, sir.
Okay, this is 23 CR 214, State of Ohio versus Christina K. Jenkins. It's arraignment, Ms. Jenkins appearing from the jail. You were indicted by the grand jury yesterday on 2 counts of trafficking in a fentanyl-related compound, 2 counts of possession of fentanyl-related compound, all 5th-degree felonies. The first count alleges that the offense took place on about January 23rd in this county, and you allegedly sold or offered to sell fentanyl-related compound. Count 2 alleges on about that same date you possessed that amount. Count 3 alleges on about February 21, 23, you sold or offered to sell fentanyl. And count 4 alleges on about the same date you possess that. All of these are fifth-degree felonies, which carry possible term of incarceration, 6 to 12 months, fine of $2,500, and a possible license suspension of 6 months to 5 years. Now, you're entitled to have an attorney, and if you cannot afford to hire one, the court will appoint one for you. I believe you filled out a financial disclosure form. Is everything on this form correct, Ms. Jenkins?
Yes, sir.
And when's the last time you were employed?
I'm employed now.
Where do you work?
I work at home health care, Perfect Hands out of Washington Courthouse.
Okay. All right, well, the court will find that you are entitled to appointed counsel. And I will appoint Attorney Danielle Witt of Hillsborough to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. Your first pretrial will be set for December 13th. At 1 p.m. Final pretrial will be January the 3rd at 1 p.m. Trial date will be set for January 25 at 8 a.m. And you don't have any previous felony conviction, do you?
You know, I had one 25 years ago.
Oh, you did?
Had through the welfare department.
At where?
Through the Job and Family Services, pressed charges against me 25 years ago.
Okay.
And I paid the restitution and all that.
Yeah, I see in 1997. Is that what you're talking about?
I think so. Yes,
You were
sir.
arrested at that time.
Yes, sir.
But I'm looking here. Okay, it says theft, but it doesn't say any disposition. Were you convicted of that offense?
Yes.
Oh, okay. Well, thank you for your honesty. All right. Oh, here it is. I found it. It says you got 14 days in jail, so that must have been a misdemeanor.
Yes.
Okay. It said in here it says F for felony, but you got 14 days in jail, so I'm guessing that must have been a misdemeanor. But anyway, I'm going to release you on your own recognizance, Ms. Jenkins, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony. And if convicted, prosecuted and be sentenced regardless of what happens in this case. Now, you'll be under pretrial supervision of the probation department at 117 East Main Street. And it's here in Hillsborough, it's across from the Flagway Station. I don't know if you're familiar with it or not. You need to report there immediately upon your release. I think they close at 4. If you can get there before 4, fine. If not, you'll need to come back tomorrow and report to them by noon. You'll be required to report to them once a week for 4 weeks, and after that, as they determine, you'll have to keep them, or you'll have to undergo random drug testing, provide phone numbers for home, cell, and employer, recommended by probation. You'll be evaluated for substance abuse or mental health issues. If any treatment's indicated, you'll enroll in and follow that during the pendency of this action. You'll be under house arrest, meaning you have to be at your residence at 332 Linden Avenue in Greenfield. That means you have to be there at all times unless you're working, or if you're going to and from work, medical appointments, court proceedings in this or another case, appointments with an attorney or probation officer in this or any other case. You can also attend any church services and family holiday events during the holiday season. However, you have to go directly to and from those places, and you'll need to notify the probation department in advance of when and where you'll be going so that they can monitor that. In the event that you've violated any of these conditions, then the court could revoke that bond and have you held to further order of the court. We'll notify your appointment or your attorney of her appointment, and like I said, make sure you report to the probation department as soon as you get out of jail. And again, if you can't get there before they close today, you'll need to be there by noon tomorrow, 117 East Main Street. All right, you have
Yes,
any
sir.
questions?
Yes, sir.
All right, thank you. You can also get your attorney's number there from the sheriff's department when you process out. All right, thank you. I believe that's everybody, right?
Yes, Your Honor.